his mother-in-law suffered a grave stroke yesterday, and he and Chris went to Texas where she's residing. So let us remember the guys' hearts and prayers and our thoughts that she may have a complete recovery from her stroke. I'd also like to remind everybody who has mobile devices of whatever type you might have to please turn off the noise element and have vibrators on. But we'd appreciate having those things turned off. Okay, we've reassembled here to deliberate on the recommendation on the Dimucci application for rezoning, conditional use permit for a land unit development, and the preliminary development plan request. Public comment portion for this procedure is now closed. No additional unsolicited comments will be accepted at this time. Our order of business will start with individual commissioners asking questions of the staff, the applicant, or others in attendance here this afternoon. When answering a question from the commissioner, please come up to the podium, which you see over here, and identify yourself, state your address, and who you represent. Please speak clearly into the microphone, and I've been told by the people that are running the audio system that if you can speak within about 3-4 inches of the microphone, it should work much better so we don't get a feedback, because we've got, I think, 7 or 8, 9 microphones here. Please speak clearly into the microphones and direct your answers to the person that asked. Please address any questions that you may receive from the commission. To start off our questioning, we will call on the commission members by seniority. I would ask each of the commissioners to be prepared with their list of questions and to identify specifically whom you want to answer your question. I would also ask that each commissioner hold any comments that you might have until all of the commissioners have had an opportunity to ask their questions, and we will at an appropriate time have an opportunity to do our own discussing among ourselves. Once all the commissioners' questions have been asked and answered, we will accept a motion regarding the recommendation on the applicant's request. Once the motion is made and seconded, we will recognize individual commissioners who can now make comments and debate the issue. Once all the commissioners who wish to comment has been finished, I will call for a motion for the vote. We will then have a roll call vote on the motion, and that recommendation will be sent to the ZBA, who in turn will go to the PB&Z, who will finally go to the county board. I would again remind the commissioners and those in attendance that the RPC here is an advisory body, and our recommendation will go to the Zoning Board of Appeals, the Planning, Building, and Zoning Committee, and to the full board. It is the responsibility of the RPC to look at the regional impact of the proposed application. It is not this body's responsibility to consider specific detailed conditions. If we decide as a group that we want to include certain general terms such as stormwater management, building size, traffic, setback use, etc., that would call to the attention of the ZBA, PB&Z, and the county board to take special consideration into these matters. And this would be appropriate for this body to make those kind of recommendations. I would remind everybody that is here that the ZBA is responsible to look at the details specified in the application and follow the extensive public testimony and a public hearing.
We apologize for the rocky start.
That would be applied to the final development plan. I would encourage all people who have attended the RPC meetings, this hearing that we've been conducting, to attend the ZBA at their next meeting, which has been announced. And at that time, you can have an opportunity to once again give your testimony and make your presentations. It is not appropriate for any kind of presentation should be made at this meeting here today. We've heard the applicant's presentation. We have received staff's report. We have accepted extensive public comment. I realize that this is an emotional issue for everybody that's involved here, and I would hope and pray pray that everybody will conduct themselves in a very civilized, with a lot of concern and consideration for one another. At a certain point, we will take a break, probably around 6:30, for those that need to go use washroom facilities, and those are over on this side of the hall. I would like at this time to call on Eric Wagner to have the floor and for him to make a few brief remarks.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. I would first like to reiterate my previous comments from the last meeting about the review role of the Regional Planning Commission. The RPC is an advisory body on development requests when such requests involve the development of potential regional significance when inconsistent with the Lake County Framework Plan's future land use map. As such, and as stewards of the Regional Framework Plan itself, the RPC is responsible in such cases to provide an advisory recommendation on pending requests and, in so doing, to take into account the criteria for review. In this case, as a reminder, the application consists of 3 separate requests. Number 1, a rezoning from estate to general commercial. Number 2, a conditional use permit for a planned unit development. And number 3, a PUD preliminary development plan. As previously noted, the review criteria and staff's response to these criteria are contained within your 15-page staff report. The criteria address, in part, consistency with the Regional Framework Plan, and in part, the standard criteria for rezonings, conditional use permits, and PUD preliminary development plans. To simplify these criteria for your discussion, they can be distilled into 3 main themes. Number 1, is the proposal consistent with a commercial trend of development in the area? Number 2, will appropriate commercial infrastructure be available to serve the project? And number 3, is the proposal compatible with area development? To reiterate, the review role of the RPC is to consider the proposal broadly and to provide a general recommendation. The ZBA's function, in contrast, is to convene the official public hearing, take sworn testimony, and provide an opportunity for cross-examination, and on the basis of all the information provided at the official public hearing, to craft detailed, precise conditions in making its advisory recommendation to the Planning, Building, and Zoning Committee and County Board. The broader role for the RPC, however, does not preclude the RPC from providing the ZBA, the committee, and the county board with advice that those bodies further explore in more precise details areas of concern. We've heard a number of such concerns raised in the course of the public comment period, and these concerns include such issues as proper stormwater management to control release from the site, building bulk issues, floor area, impervious surface, setbacks, traffic, ensuring permanent open space, compliance with the applicant's pattern book, buffering and lighting, and use restrictions. The RPC has the discretion to advise the subsequent review and decision-making bodies to take these issues into further account as they craft specific development conditions. Staff is here in full tonight and will be available throughout the deliberations to clarify any issues and to provide the Regional Planning Commission with requested information. Thank you, Chairman.
Thank you, Eric. Okay, Paul Geishock was the one that has the longest seniority. He's not here, so Jordan, you get to be the lead-off man.
Thank you very much. I will begin my question with the Dimucci's, with the thought that a lot has been made about the county's sort of 11th hour alert, notification to municipalities that this is going on. So obviously, you can assume that a lot was going on behind the scenes. But I'd like to. And I can understand why the municipalities were concerned about it. So I'd like to a lot has been made about the boundary agreement between North Barrington, Hawthorne Woods. So I would like to ask the Dimuccis, while this boundary agreement was being negotiated way back then, what was your input? Did the municipalities contact you? If so, what was your input into that? Or were you taken by surprise by their agreement?
Hi, everyone. Is this on? Yeah, my name is Mark. I'm the attorney for the Dimuccis. The short answer to your question is no. The villages dealt with each other on one of several IGAs, the boundary agreement. And the Dimuccis were not consulted. I also understand that the county was asked to endorse the boundary agreement, but they weren't brought in early, as they should have been. And while one of the members of the county may have indicated that he supported boundary agreements in general, the county refused to endorse the boundary agreement. And I believe at that point in time, that was led by Ms. Newton from Hawthorne Woods.
Okay, and so then to the county, I'd like to ask Eric, the timing of the notification. What was the timing and why was it then and why was it not before or why was it not later? Because it seems like there's been a lot going on about we weren't told this, we weren't told that, we were left to. So what was your thought behind that?
As it relates to the IGA, or the intergovernmental agreement that was developed between the two villages, I think the North Barrington Comprehensive Plan of 2004 states it somewhat succinctly. It states that an attempt was made to have Lake County concur with the village's agreement to prevent the incompatible development of the Southern Corporate area. And the initial overture of Lake County was not successful. The agreement, the terms of the agreement, had already been worked out between the two villages before the county was officially asked to participate and to essentially concur with that agreement. So the request to the county to participate was not made at the beginning of the development agreement.
I'd also like to add, if I may, this matter was originally brought to both villages 10 or more years ago. And that I believe those discussions were held with Mr. South of North Barrington and Mr. Hunt of Hawthorne Woods. Those discussions failed, as everyone knows. The result was all of these various agreements in which the Dimucci family did not participate. And they ultimately...
and it was not notified of either, correct?
I'm sorry?
It was not notified of while these conversations were going on between municipalities. The family that owned the property wasn't notified, is that accurate?
That's correct. There was no request for participation.
Is there anybody from any municipalities with the boundary agreements who'd like to respond for what reason they wouldn't have been notified? Okay, not hearing anything. Then I think part of the next question I had that I was thinking about was most of us have been on this board for a long time. We are a citizen board, we're independent, we don't answer to the county board, we don't answer to the staff, we take staff advice, of course. We are representatives, many of us were probably in a seat just like yours, we became active in our community and spoke either sometimes for, often against these types of things, which is how we probably got onto some of these boards. So we're well aware of the nature of it, and in the absence of a municipal agreement, the county is local government, so this is local control. But my question for you is, with the basic trend is to throw every negative out and then just see what's going to stick, essentially. One of the things that I am interested in is the traffic, and obviously a concern for everybody. Why is there no accurate traffic figures or traffic studies, and what is the absence? It seems like our traffic information is very, very dated. Is there a reason for that?
The proper timing of traffic studies for a development of this nature will be dependent upon the timing of the final development plan request. request is made, it's going to identify the specific uses that will drive the analysis of the transportation impacts. At that point in time, the development as proposed would have to meet all of the requirements of both the Lake County Access Control Ordinance, which governs the access to and transportation along Old McHenry Road, which is the county road, and the requirements of IDOT as well, which governs access to and transportation across US Route 12. That's the point in time at which traffic studies would be able to provide the detailed kind of information about what sort of improvements would be necessary, additional right-of-way dedication, and so forth. It's not timely at this point. However, that is one of those issues that will have to be looked at very carefully and fully reviewed and costed out as part of the final development plan process.
Is there any of the consulting planners for some municipalities, I've named the gentleman who escapes me now, I think we got an email from him or a PDF from Tesla, anybody from the organization? Sir, can I ask you a question?
Tesca Associates is a consultancy that works with
My
a
name
number
is
of
Dean
big
Brown,
villages.
President of Tesca Associates.
And you can correct me if I'm mistaken here. It seems to me that there is a basic general consensus that there would be some, I mean, the Dimuccis didn't just jump off the combine farm one day and decide to go commercial with this. It's been in the works obviously for a very long time. Some efforts have been made. In the absence of their plan, as a professional planner, what do you see for the property?
I think there's a difference between review of a development proposal and a long-range plan, which is your responsibility. In a long-range planning process, we look at not the trend of development, which is a zoning issue, but the intent of the county for economic development, for a mix of land uses, and the judgment on what is best for the area doesn't look at the specifics of the site, but at the larger community.
No, so what I'm saying is, take 10, 15 years down the road, in your view, what's going to be on that property?
A mix of uses.
Mix being commercial, residential?
Inclusive of residential, inclusive of some neighborhood supportive retail.
So what would you say, if you're looking at your crystal ball as a planner, what is the maximum amount of footage on the roof that your view of that property would support?
I'm not going to speculate.
Okay, all right. I appreciate that. And then back to the county, concern was raised about Old McHenry Road, the possibility that might obviously get more traffic. Is the county prepared to deal with that, including widening the road, et cetera, what would have to be done, assuming that would become an issue?
Absolutely.
And you've talked to the department.
That's right. And the Lake County Division of Transportation here tonight, and representatives in the room tonight. As I said before, the final development plan stage will involve very extensive and detailed traffic studies, which will result in analysis and conclusions as to the amount of improvements required. And those improvements will be borne by the development itself. That they will have to cover the costs of improvements on the road, additional dedication of road, and so forth.
Okay, another issue that I had is I can see where there would be great concern, especially with large retail development, in police patrol, to deal with the day-to-day issues that would arise in the shopping center. What is the sheriff patrol going to cover this, or what? How is this policing of this property going to be done, assuming the date gets developed somehow? What's been done, and also has the feedback from the sheriff's office been sought on that?
The sheriff's office is aware of this. This is essentially an area in which the county sheriff's office, sheriff's department has a presence already. We have 5,000 corporate residents within proximity to the site. We have contracts of service with some of the neighboring municipalities, including Barrington. We provide the extent that any additional controls would be necessary is based on the basis of the uses that eventually develop on the site. That kind of decision would be made about making different allocations of staffing down there.
And my final question, I've heard a lot about all the empty retail in the area. Does anybody have a figure, what's the largest single empty retail space? Is there a breakdown of what, obviously, large tenants in large buildings, what is the breakdown, not the total empty space, but is there some sort of breakdown of what's available, what square footage that is? Is there anything done along those lines by anybody?
We don't have that information. I would point out also that the development proposal is for commercial. It's for non-residential. It does not specifically call for a balance of retail or a particular mixture of retail and office or even office. Service uses. General commercial with a PUD in this particular case, based on the way the application is presented, does not envision a specific locked mixture of land uses. And at the time of the final development plan process, when the developer is secured and when a plan is presented, that's the time in which that information will be made available in terms of, whether this, and the market's going to, it's a market dependent analysis. Whether
I understand.
the mix of uses is going to be different.
No, but obviously 800 square feet, 1,000 square feet is a big space, and we're going to assume there's some big boxes. That was my question. Another question, during the, as people have sort of envisioned what the Dimucci should be doing with their property, during the building boom a dozen or so years ago, was there any movement towards this property for residential development?
I'm good with short answers. The answer is no. There is no residential, and there has been no residential interest in this property. I think as we testified before, there have been no new single-family detached residential requests up and down Route 12 for 20 years. There have been some multifamily. The balance of it has been commercial. I also know that if you went ahead and made an attempt to develop this at some kind of estate zoning, it's not impossible to do. The cost of the infrastructure per unit could not be absorbed in today's economy or foreseeable future.
And I have one final question I'd like to ask. There was an issue raised about flooding at some point that now, I think anybody knows stormwater management knows, those developers knows the tendency, what I've always heard has been, to much of the developer's frustration, is to overbuild. That stormwater management is very diligent in that regard. Is there any instance where stormwater management has been involved in something that has caused flooding? Is there any knowledge of that, or anything where something was underbuilt and caused a larger problem than before stormwater was involved in something?
I'd like to address this in the context of this particular site, and perhaps I'm misinterpreting your question, but this particular site has not been engineered in the past. Off-site release of stormwater is unrestricted. It's a farm field. There's no formal system of detention or retention that would provide for appropriate.
No, I understand now, but at the point of development, you would have to bring stormwater management into it.
Yes.
And at that point, which leads to the question I was asking, so assuming, as it would have to assume that stormwater management, assuming that it took the next step and a developer came forward and storm management got involved, is there any reason, based on history, to believe that stormwater management would not do a thorough job and thus cause some of the flooding problems that I believe the village engineers had fretted over during the comments?
I won't speak directly to any comments made by the village engineers, but I will say that stormwater management controls that are governed by the county are very stringent. The proposed restrictions pursuant to the applicant's pattern book and any conditions that may be further imposed at the ZBA stage and beyond will ensure that off-site stormwater issues are prevented, such that there's an appropriate flow off-site and no negative downstream impacts. That's the purpose of getting into that level of review and ensuring that through conditions that will be verified through a very detailed engineering process at the final development stage, that those restrictions are going to work the way the condition intended them to.
Okay, that's my question. Basically, there was some worry about that, and I thought, well, has there been an issue where this had come up that would be legitimate? But, okay, with that, we don't have my questions, and I'll turn back over to the chair.
Okay, thank you very much, Jordan. Randy?
Greetings. I know that I'm going to have an opportunity to follow up with other commissioners' questions, but I'd first like to follow up some of Jordan's questions before I get in my own. And this is Eric Wagner to start with. Eric, you said you answered Jordan's questions about the county's lack of involvement with the IGA. The county's taking a position that they're not honoring the IGA now. That being the case, why is the IGA listed as one of, I believe, only 4 in the regional framework plan?
The regional framework plan in the intergovernmental planning chapter referenced a number of boundary agreements by example in order to demonstrate that local governments have the ability to do local planning and participate in intergovernmental planning agreements. But to address the issue of intergovernmental planning is one that I think should provided sufficient context. What that intergovernmental planning chapter specifically demands of the county is that in the context of boundary agreements, that to the extent that the county were to participate in such agreements, that they be involved early, that they be given full opportunity for participation, and that they have a seat at the table. There's an example of an intergovernmental planning process within the subject area that was successful, that did involve the county at the very beginning, that involved extensive discussion all along between the county and the local villages, including North Barrington
No, I don't
and
mean-
Woods, and that's the Route 12 planning.
I understand that, Eric,
This
but my
is
question is, if this
Lorraine
particular
Ray, Commissioner Lorraine Ray.
although there are others, types of
Speaking to Eric
agreements
Wagner
between
of the staff.
county was listed as one of only, I believe, 4 as models to look to, because we as a county honor agreements between municipalities. Isn't that the way in which it was brought up?
They were not specifically identified as models, they were identified as examples.
And you also mentioned that a traffic study is not going to be done here until there's a final development plan. And the reason for that is because you can't do a traffic study until you know what the uses are, because you won't know the traffic impact until you know the uses. Isn't that right?
That's exactly right.
I'm sorry?
That's right.
Okay.
The extent of improvements, the extent of access requirements is a
Because-
function of what's there.
Because what happens is certain types of general commercial development would spin off more traffic than others, right?
That is correct.
And as would be the case with fire and police that you were going to ask about, obviously the county has our own sheriff's department, and they do a fine job. But the impact on fire and police would not just be on this site. The impact would be on surrounding areas, much of it municipal, around this site. Isn't that right?
Police and fire would be those services that are provided to any development in the area. The fire protection is provided by the Wakanda Fire
But
Protection
the
District.
impact, for example, of somebody going to the mall and having an accident in Hawthorne Woods would fall on Hawthorne Woods. Isn't that right?
In terms of fire protection, it's a separate district. It's
All right,
not the
let's
village
just
of
talk
Hawthorne.
one at a time. Let's talk about police. Okay? The impact of the police is not just on the site, There's traffic accidents and other things, crime that occurs because of commercial development coming in, that would occur outside of the site proper, and therefore likely in the surrounding municipalities, isn't that right?
Law enforcement is a function of mutual aid. There's a mutual aid concept which governs the types of law enforcement response and first response.
Are we as a county going to provide additional monies to the municipalities in order to help support the impact that this retail center would bring?
Any impact in terms of fire protection, law enforcement, that could be potentially raised by development on the site would have to be addressed and should be appropriately addressed in terms of conditions. I'm not going to sit here and speculate as to any funding that would be necessary.
So once again, until the county knows exactly what's going to be placed here, the county doesn't know what type of discussion should occur to address the impact. Is that right?
And those discussions would be, I think, very appropriate as subjects for conditions that could be imposed.
And that would apply to both police and fire,
Police
right?
and fire, that's correct.
So once again, just like with traffic, we really don't know what this is going to be, so we don't know the impact. So we don't know what studies and discussions we have, right?
Again, the purpose of the setting of conditions is to ensure that those needs are anticipated and appropriate provisions can be made at the appropriate time when that information does become available to ensure that those issues are addressed appropriately.
And so, since we don't know the specifics, and I think the term we all used was that there's no specifics that are locked in at this time for the land use, that you said it could be offices, it could be retail, it could be restaurants. We don't know at this point. So because of that, we really don't know the impacts that this is going to have at this point, right?
There are a number of impacts which can be assumed right now.
Well, we're talking now, following up on Jordan's thing, he talked about traffic, police, water, and runoff. So we don't know, as we sit here now, what the impacts of those will be. And we don't have a study as to that because we don't know what they're going to put in, right?
These are legitimate concerns, and they are legitimate concerns in terms of stormwater management, providing for adequate law enforcement and fire protection and so forth. It's very appropriate to design conditions at the preliminary development plan stage to ensure that those issues are addressed appropriately.
We're not worried about that here. What we're worried about is the impact of the regional impact here. We're worried about how this proposal affects, and is it consistent or inconsistent with the regional framework plan? That's what we're here for, right?
The purpose of...
Just for that one reason. You said it in your opening, right?
That's right. Developments of regional significance.
Right. And so if we don't know what's going to be put in, then how do we know what the significance of it is going to be?
Again, the idea is if you, in your professional judgment, and following your review, the Zoning Board of Appeals, the PB&Z Committee, and the County Board in their judgment, consider on the basis of all the information that's been provided to them from staff, consultants, from the public, feel that certain issues are relevant and that certain impacts need to be addressed, that's the appropriate place for setting of conditions.
I guess I'll have to ask my question again. We don't know what's going in. If it's going to be offices, the impact on the surrounding neighbors is significantly different than if it's going to be a big retail mall with restaurants or any other kind of use that's permitted in general commercial. So we have to look at the impact as it applies to the region, including the neighbors. But my question is, how, you're telling us that because of this pattern book, that we should be able to make a general recommendation and we can ask for specifics. Is that what you're saying? All right, I'll get to the pattern book later. But at this point, I just want to be clear that there are no specifics here?
There are a number of specifics, actually.
Not as to what's going in, what type of businesses, and all of that. We don't know what a possible developer is going to want to build here.
That is correct. There's no specific series of land uses that are proposed.
Okay.
The layout is general, defined by the 53-acre confined box, if you will. And the purpose of the preliminary zone plan here is to identify and lock in preliminary conditions of approval that will govern both those impacts that are already foreseeable and understood in terms of performance measures. Ensuring
and
that
I'll get to what the requirements are later, but I just wanted to talk to you about what we know or don't know.
And then, as I said, there are certain impacts whose precise definition is not yet known, and the appropriate time to address those is the final development plan stage, subject to appropriate conditions in the preliminary development plan stage.
My next question would be addressed to the village attorneys, including Mr. Braithwaite to begin with. I have a question for you, if you don't mind, and also if there's an attorney here I can't see from Hawthorne Woods also. Do either of you know in your careers and experience in municipal law if there is any precedent in this county or any other county for not honoring an IGA, whether or not the county is a signature to it?
In my experience, it covers well over 50 years in municipality. I do not know or I have ever heard of any county government ignoring an IGA, especially one that the county encouraged the development of when it was first adopted.
This is Attorney
And there was
Braithwaite,
much ado earlier about
a village attorney for a number of
whether or not the
local
property
villages.
owners were involved, in addition to the county being involved in this, the discussions between the municipalities as to this boundary agreement or IGA. Is it your experience that IGAs are created between municipalities without the involvement of the specific property owner or owners?
Generally, that is correct. Every IGA is handled separately as far as the involvement of the property owners. In this particular instance, and I was a part of the IGA process, the owners of the property, the Dimucci family, certainly had every reason to be aware of the IGA. The IGA was widely publicized, was widely discussed in the press, as well as in the public minutes of the lines. It was generated over an extensive period of time, and at no time, to my knowledge, did anyone from the property owners come forth and say, I have some suggestions, I have some things I'm asking for.
So it would be common for the municipalities themselves to discuss and enter into these boundary agreements without including various property owners in that.
Yes, it has been the standard that the boundary agreement is developed without discussion with the property owners. There have been some statutory changes in the last, I must say, probably 4 years, which caused property owners to have some knowledge of notice of such IGAs. But for all the time that this was developed and discussed, it was between the two villages in question.
Thank you. Would the attorney for Hawthorne Woods like to add? Oh, there you are.
My name is Cam Shapiro. I may not have one
You have to speak closer to the microphone.
Sure, I mean, you know, the wonderful 50 years of Mr. Break that he has, but you can add 25 to his 50, so collectively we're 75. And I agree with his, or I have a similar answer.
This is
to
Dan
his
Shapiro,
relative
village
to the
attorney
county
for Hawthorne
trying to
Woods.
kind of trump an IGA between two municipalities. I've never seen it.
Okay, and I have a question for either the lawyers from the villages or the planners regarding the pattern book. And I'm not sure which factor to address it to, so whoever wants to step up and answer may. In the pattern book, I was not able to find very much specificity as to actual footprints, as to permeable or impermeable surfaces, as to the drainage patterns that would occur, or as to any specific type of commercial, except for that which is allowed in the GC. Would any of the people from the municipalities, have you seen anything else in there, or would you like to speak to that lack of specificity in the pattern book?
My name again is Lee Brown, Testing Associates, representing Board of Farrington. Briefly, pattern books are a process related to style, not to footprint or impact. They are guidelines. They're suggestions that allow for a quality or character of development, but not govern the footprint or the impact.
Have you, in your experience, ever seen a request for a zoning change and PUD based simply upon a pattern book?
No, this is not either. This is a request for the ability to make use of the site under a zoning broadly that references a design standard pattern book, but is not wholly reliant on that, because the uses that are permitted in that zoning district are permitted in that zoning district, whether or not the pattern book is applied.
Thank you. It's my understanding that there has to be a site plan. Sir, you can stand for 1 second. That there has to be, to receive PUD approval, according to the county's rules, there needs to be a site plan. And that site plan would have basic, dimensional specificities, footprints, building sizes, height detail, things like that. Have you, in your experience, ever seen a request like this where there's none of that specificity or site plan included?
My understanding of the county's rezoning application requires that. It's part of the documentation that's required.
Right. And reviewing the documents presented here, have you seen such a site plan?
Yeah.
I can just have a minute. Is any of the engineers here specifically from North Barrington or Hawthorne Woods? Is there an Andrea Franklin here?
She's her way.
She's on her way. Okay, I can hold that for a moment longer. Is anyone from Baycott here? And I have a couple of questions for you all.
Commissioner Lorraine Ray has just asked to hear from representatives of BACOG. In the black shirt is Janet Agnoletti, who is the executive director of BACOG, along with another staff member.
Involved in groundwater studies in our area, isn't it right? And you'll have to speak into the microphone or it can't be heard, so please introduce yourself.
Janet Agnoletti, I'm the executive director of BACOG. I'm Kathleen Leitner, I'm the recently past chair of BACOG and village president of Tower Lakes.
This particular proposal does not have municipal water to it. It will rely on wells. They say until 2018, but who knows? Can you talk to us for a moment about what effect an 800,000 square foot commercial site would have on the wells and surrounding residences in the area?
I spoke to our consulting hydrogeologist about this question, and the answer is really very simple. We don't know what the development is going to be on the site because there is no site plan. We can't evaluate what the effect will be on the groundwater because we don't know what the uses are going to be.
And you're aware that the people surrounding, the residences surrounding this site and in the expanding area out from it are all on private wells, right?
You know, I haven't looked at that, but I believe that they are. The communities in the area are mostly on private wells, and which are in the shallow aquifer system. The vast majority, which is water that is within the first 100, 200, maybe at the most 300 feet below ground surface. And it's a shared system.
And any new commercial, general commercial site would have to have a sprinkler system too, right? And that's fire protection. Did you talk to any of your people about what impact a drawdown, a God forbid emergency would have on those surrounding wells if they had to use their sprinkler system?
We have not evaluated that, although we would love to know what the uses are going to be so that we could evaluate that.
Switching gears a moment, have you and BACOG done an evaluation of whether or not there is a need for additional general commercial of this magnitude in our area?
We haven't specifically done an evaluation once again because we don't know what's being presented here. Deer Park Mall is just down the road. There's a lot of vacant commercial space in Lake Zurich, some in Wakanda, and I think it probably would help all of us to know exactly what's planned here in order to evaluate that.
Thank you. Thank you both. Eric, I don't know who of staff to address this to, but I have a question regarding the providing of the water to the site and that agreement. I don't know if it would be you or not. What is there that says that the water will actually be provided by 2018?
I think I would refer to our guy, the attorney for the applicant, the applicant's agreement with her.
On our website is a copy of the sewer and water service agreement for this property. In that agreement, with regard to water, it states that at such time as Lake Zurich is able to provide us water, it will, and we must accept it. And that would be municipal water. Prior to that time, we have the ability to utilize wells for various purposes. The wells would be subject to a depth analysis to be certain that there isn't drawdown.
But Mark, my question was, what is the commitment that there will be municipal water by 2018?
It's an agreement and it's on the website. It's both on the counties, I believe, and it's on ours. Okay. The entire agreement is available, and water is to be provided by Lexler, and we are required to accept it.
And is that consistent or inconsistent with the IGA?
The IGA provides that, I believe Hawthorne Woods has the right to consent or to waive its right to provide water to this site. And it has not done so. But that agreement expires in 2018, hence the date. And so, if you look at a timeline, by the time we seek approval, obtain a purchase of which we don't have, do design work, do site work,
I understand the process.
it's going to be close to that period of time.
That's not much. Thank you.
So likely it will be served by quality water.
And is there anyone here from stormwater management? We said there was someone here from stormwater management.
That again is my engineer.
Okay, I'll save that question also.
Kurt Woodford is here.
Are you referring to the county's SFC
stormwater
management?
Yeah.
For Wolford, she mentioned her
Oh, good.
SFC is here tonight.
Good, good.
Good evening, I'm Kurt Wolford, Chief Engineer with the Lake County Stormwater Management Commission.
Where does the outflow of water go primarily from this property now?
The property is in two different sub-watersheds. A majority, I'd say 95% of it, all drains to the southwest under Route 12. And then there's a culvert there into the Windstone development. And when Windstone was designed and developed, they designed that entire subdivision to handle the undetained release from the property, which is around 100 CFS. Very large amount of undetained runoff. Then it travels down towards Flint Creek to Miller Road into the Flint Creek watershed. That's the natural drainage pattern, and the watershed development ordinance requires that any development would have to maintain those same drainage patterns. None of that water would be able to discharge to the north to the Tower Lakes watershed. It would have to maintain the same outlet towards that culvert through the Windstone development that was designed to accommodate undetained release. The development will be designed, obviously, with stormwater management controls, reducing the amount of water through the Windstone development down to Miller Road and into Flint Creek.
We were told during some of the testimony or statements here in the earlier meetings that Miller Road floods already. So the water from this, and if it was impervious surface, then the runoff from that, which is different than an agricultural field, would then run under 12 over into Miller Road and go into Flint Creek drainage area. Is that right?
That's correct. Currently, without a development on the Dimucci property, there are known flooding hazards along Flint Creek, along Miller Road, and work has been done by North Barrington and is being done by DOT currently in planning stages to address existing flood problems.
Right.
Through the development, the release rate will be controlled. Right now, there is no control. It all runs off. With addition of impervious surface, there is additional runoff that's generated, hence the need for detention basins, which would slowly release that.
And regulate it, right?
And regulate it.
Okay, but at this point, we were told that they're proposing drainage into Tower Lake, but you're saying that that would not be permitted.
Well, they could probably drain a very, very small portion of it
So the majority of the drainage needs to go along the existing way, which is under 12, down by Miller Road and into Flint Creek.
That's correct.
Okay. Thank you. I need to ask some of either of the villages if they have a response, to my question, which is the housing sales we were told went up in Deer Park. We were told that by the Dimucci family's experts. And we've also were told during some of the course of the dialogue here that was new home sales versus existing home sales. Can either of the municipalities come up and talk to us about that aspect, if you've looked into it relative to what a commercial development would bring? The Midwest? Yes, yes, I will say. Is it not a person here that can address that, or should I move on?
Yes, yes,
You see the one that made the testimony?
Yes, sir.
Okay, then you cannot answer the question.
Great, thank you.
Wait, time out. I thought this was a time for the municipalities to bring experts for us to query. They were not given a presentation time with experts, so my understanding is I'll take that under advisement, but I would like to ask a question. Do you have information on the housing sales?
Not at my disposal. I do typically only have access to.
Okay. And typically when a large commercial development comes in, such as Deer Park or the one proposed here, can you have a typical answer for me as to what happens with housing sales in the area?
Well, first
Property value?
First off, my name is Mark Kohler, and I'm a trustee for the Village of North Barrington. I'm also a local realtor and have been for the past 36 years. I can only give you general.
Well, that's fine. That's fine. Thank you anyway. Is the engineer arrived yet from either of the municipalities? Yes. Okay.
Lee Fell with Chris Burke Engineering, village engineer from Holland Woods.
Hi. Are you familiar with the Soil and Water Conservation District of Lake County?
Yes.
And if you, Soil and Water Conservation District for Lake County has indicated that the soils, contrary to what the Dimuccis testified to, the soils here are hydric soils, and it's not recommended that there be commercial building, especially large structures or even homes with basements. Can you speak to that?
I haven't seen a geotechnical report for the subject property. I know the site plan and what type of roads you need to be on that, so I guess I cannot answer.
Eric, is anyone here from Soil and Water?
No.
Is anyone here from the county that can answer our questions about soil and water?
Not in that real specific,
Well, this is part of the Dimucci's information packet. So I need to ask a question about it. Is anybody here that can answer?
Do you have a general question that we can?
I'd like to know, yeah, I have a specific question. On page 15, building limitations, it indicates that certainly close to 75 or 80% is not recommended for commercial, according to our own soil and water. So I'd like to know how we can be recommending something of this magnitude with hydric soils.
We're going to hold it a second.
I think I added it up, it's about 70% soils are very limited for commercial. Even roadways are limited because of the saturation zones. So the Dimucci's claimed that there was no depressional storage on the site, but actually there's some on-site storage and several drainage areas leading off-site. They also used a floodplain map as a wetland example, which is just not appropriate. And I was hoping that either one of the municipal experts or one of our county's experts would straighten this out for us.
Well, we're not, well, staff here today is not prepared to specifically address the specific soil types and its condition and its impact on potential development. And the suitability of development. Soil loading is something that is certainly relevant to the actual design phase. Once we get there, obviously the site is within several different mapped soil types, each of which has different loading characteristics. And so at the point in time in which we can identify where buildings are impervious to go.
So once again, because we don't have any specificity, we don't know what the impact is going to be.
Again, that's an issue that would be determined on the basis of design.
Okay. Then I'll ask you, Eric, or whoever else from the county, what are the contingency plans for development failure here? Is there anything built in? I didn't see anything in all the paperwork we were given. And right just south of this, the Kmart in Lake Zurich and many other stores have been empty. To the north, it's the Dominic's that's been empty. You know, we have to look as to whether or not there's a need in the community for this kind of use that would change the use on the property. So what are the contingency plans for development failure here that the county proposes?
And if the question relates to a development which is built and which eventually fails, subsequent to the original development and the existence of tenants or subtenants on the property, you're asking what contingencies would occur?
Is there anything built in the agreement that you're proposing between our county and these property owners?
The process today is an entitlement process in which we're identifying the suitability of this particular property for future development. Contingencies in terms of ensuring that a development cannot fail or that development, once it's sited, stays
I'm not asking that, I'm just asking whether or not, it's a simple question, whether or not there's, and I couldn't find it, there's any contingency plan in there for failure.
And we don't have a contingency plan for this because that's not something that's germane to this stage of development.
I'll move on then. Getting to our Article 5 zoning districts, and Eric, you can either field this or send it to someone else. It says the general commercial is not a neighborhood-oriented district and is not generally appropriate for application within residential areas. It's intended to be to accommodate existing commercial uses. It may also be used to accommodate new development. In all cases, new development in the GC district should be adequately served by infrastructure. And at this point, the water is from wells. And our priority in this county is to protect, one of them is to protect our residents. And the county residents that live surrounding this are all on private wells. How are we justifying allowing the development of unknown size and unknown use to put in private wells, basically, that could destroy the wells of the surrounding residents?
As Mr. Iden pointed out a little earlier, the timing of this development in terms of the complexity, the size, securing a developer that would have ultimately design a site and design the site for all the uses is going to take several years. 2018 is the trigger date at which point the village of Lake Zurich would provide water to the site through agreement with the property owner.
So why don't
that's
they
consistently timed with this, and therefore provision of water is one of those things that's contemplated as part of the proposal.
So what we're saying as a county then is that we're gambling on the timeline of these developers, and what we're gambling is the water of our residents. That's what's at stake here. I don't know if you've lived on a well, but if you put a straw on the ground and suck the water out, like if there was something there and they had to use the sprinklers, or if there are a number of restaurants there or high water use things.
Arrangement would needed to be made in terms of temporary wells, if in fact development would begin.
But you're not hearing me. If those wells, when you suck water out of the ground, it affects surrounding wells.
And studies would have,
especially if there's a high use.
as part of the planning and permitting for any temporary well, should that occur, there would have to be studies done as to the impacts.
So once again, you're asking us to approve something where we don't have any specifics of what the impact will be.
Again, all the requirements of the county would have to be met at that point in time.
And then also another requirement is the preliminary plat, a site plan must be submitted and processed concurrent with the zoning map amendment. Where is the site plan here?
The site plan is in the application of the
That's that sort of lobby thing that has no specificity, looks like a tree.
It's specifically in tab 5.
This meeting, it's not like,
Good, I'll get right with her. Thank you very much. So that what we have in the book, that's what you're calling a site plan.
That's correct. The site plan consists of two elements, the actual physical plan and the design elements. There's a site plan that's in tab 5. It references both the general location of the development area as well as certain restrictions on the development of the site in terms of setbacks, the amount of maximum floor area allowed, the maximum amount of impervious allowed, provisions for open space, etc.
So there's a colored version and a black and white version of this. Is correct. Oh, okay. So there's a colored version, which is the only one that I ever saw, which is basically a blob in the one area with no specificity. So that is what you as staff are telling us as commissioners is a site plan.
The site plan, that is just a preliminary site plan. In fact, at the time of the final development plan stage, a final site plan with the precise locations of all buildings and structures and impervious and so forth will be provided and reviewed. And I would point out to Commissioner Rainey that the preliminary development plan stage constitutes review and decision on, and I quote from the ordinance, conceptual use and layout of the proposed PUD, whereas the final development plan stage constitutes review and decision on a finalized development plan in accordance with any conditions imposed at the preliminary development plan stage. This is, in staff's opinion, a conceptual review. It's a conceptual design.
I understand that, Eric. Here's the problem that I have as a regional planning committee. All right? The problem I have is you're asking us to consider the impact on the surrounding community of basically a vague block. We don't know if it's going to be retail, office, we don't know the traffic, we don't know the water impacts, we don't know the fire and police impacts, we don't know any of the other environmental impacts of this. And there are homes around this. There's a very, very important equestrian community, and our county prides itself on our equestrian community. I don't know how staff can expect us to just surmise. The only thing that I can tell you, and correct me if I'm wrong, is that we have to assume the highest density possible on this and the impact on the surrounding neighbors. Is there any other way for us to approach this when this is all we're given as a site plan?
It's important to point out again that the site plan is accompanied by a series of restrictions which do attempt to govern foreseeable impacts of any development on the site, whether it's office, retail, or a mix of the two. That's the pattern of it and all of the enumerated conditions on the site plan itself. It's also important to note that any additional conditions may be imposed at the CPA stage to ensure that any impacts which are not yet precisely determined can be addressed in the final development plan stage.
And that pattern book everywhere throughout says that it is encouraged the things that are done a certain way, not required, except on page 57 of the pattern book, where it says that it is the predominance of any one species, meaning a plant material used on the site, is discouraged. Everywhere else it just says encouraged. There is nothing that I can find in the pattern book that holds the property owners to any specificity either.
And is this a question? Do you have a question?
Yes.
Okay.
Where is the specificity in the pattern book if that's what you're asking us to use, telling us the guidelines of this? There's nothing in there to hold them to anything.
I would suggest to the Commission that there's quite a degree of specificity here. There's 51 pages of different design elements that are addressed. Now, to the extent that the language on a given page or within a given statement is insufficiently precise in order to address a particular concept or issue, that is certainly germane to further discussion of important appeal
Eric,
stage.
it's not just a lack of precision. It simply says they're encouraged to follow the various stuff in that big, thick pattern book. It doesn't say they're required to.
Right. And as I said before, if there's any need to address that language, and in some cases, perhaps the wording should be changed from encouraged to required. That's certainly germane to discussion as we move forward.
I'm looking now at UDO section 3.3.8, standard 2. You with me here?
Grabbing a copy.
I'll read it for you. The proposed amendment corrects an error or inconsistency or meets the challenge of some changing conditions in the area. And what your staff says in their comments is basically the Route 12 corridor, Deer Park. Is it staff's belief then that we should have a solid, high-density corridor along Route 12 with no breaks or buffers? Is it staff's view in your comment here that it's meeting the challenge of some changing condition in the area? There's people we heard testify that live around in that part of Route 12 in a quiet, non-lit, non-curbed, non-sidewalked residential community for 20, 30, 40 years. Those communities have not changed. So what is it that you're saying here beside the Route 12 corridor that has changed or is changing in the area?
As noted in the staff report, in terms of a comment to this particular section, this is a strategic regional arterial, and it is consistently and predictably trended commercially in recent years along the border. Not every site along the border, not every property along the border has developed commercially over the years, but over the last 20 or so, that has been a trend along the border writ large, specifically including larger developments like the Airport Town Center, Shasta, Kildeer, and a number of complexes up and down Lake Zurich.
Speaking is Eric Wagoner, Lake County staff.
Condition areas, to your point, is trending commercially along.
Not in this area. This particular part of Route 12 does not have a commercial trend. Over by Deer Park there is, and there's an emphasis there to even expand that part of retail over there. There's the Volo area on Route 12, which certainly has an emphasis on expanding their retail. But this particular stretch of Route 12 does not have any of that. There are small commercial parts of pins right along Route 12. Or, as one of the people said earlier, there are small community-supported retail, but there isn't this a trend toward an 800,000 square foot high-density development on this part of Route 12.
As I pointed out earlier, and as is reflected in the staff report, commercial development in this area and within the vicinity of the property is trended along 12, whereas any additional residential in the vicinity of the property has been off of the main highway there. There has been commercial development immediately surrounding the property in recent years, specifically the mixed-use developments immediately to the west of the property, bank, office building, some maintenance.
Well, those are just as I said, they're not mega developments. Those are small community-supported commercial that's on the Route 12 face of the property, not back behind.
But again, commercial has been the predominating trend of development along the border, both within the vicinity of the property and beyond for the last 20-some years.
So you said that one of the things that we have to look at is the commercial trend of development. But in this particular area, I guess I'm asking you, where is this high-density development in this area and the trend there? There's later commercial development in the area, but not the high density that there is in Deer Park and in Volo.
The commercial trending is not, in terms of the standard, it's not a function of whether it's high density or not, it's whether it's commercial trend or development along the border. I will point out that you refer to the sort of neighborhood-oriented development, neighborhood-supported development. And again, referring to Article 5 of the UDO, which you were consulting and asking a question, the limited commercial zone, which I think is where you were going with it's a neighborhood-oriented zone,
Right.
but it is almost uniformly throughout the county located within neighborhoods. The average size of a limited commercial zone parcel is 1.5 acres. There's only 13 areas in the entire county that have that zoning classification, whereas general commercial is the general classification for commercial development along major corridors and even local corridors throughout the county. That is a prevailing zoning classification, and that's what's being proposed here. I will also point out that the term high density is one that I wouldn't necessarily use for this property in the sense that 800,000 square feet of potential development is a maximum.
Well, that's what we as a commission here and have to look at what the maximum is.
And 50% of the site, roughly, would be preserved as permanent open space, which provides for a very significant amount of buffering of any development on that site from surrounding properties.
All right, well, let's talk about that. Let's talk about, there's uses around there that are quite vulnerable. Not only the majority being residential with their own private wells, but also the Milton Road corridor there that's equestrian, which we in the county have determined is a high priority to protect. How is standard 3 met, Eric? Standard 3 is the proposed amendment will allow development that is compatible with existing uses and zoning of nearby property.
I will point out that the development proposal that you have before you is a rezoning accompanied by a planning development. The PUD conditions that would be addressed at the ZBA stage would ensure that this approach to development, as opposed to a straight rezoning, would identify and mitigate both foreseeable impacts to those that are not yet precisely defined, and it's important to note that that particular point is reinforced by the work that's been done in the area through this intergovernmental planning process between the county and the area villages. This is the Route 12 Border Planning Council, whereby all of the villages in the county, with extensive public input, had essentially defined a vision for development along the corridor. A vision that specifically identified the likelihood of commercial development along the corridor to ensure that that development, wherever it may go, is compatible with surrounding uses. Various conditions, such as capacity or the degree of buffering, setbacks, lighting requirements, and so forth, were taken into account in this very extensive process, which lasted several years and which ultimately resulted in a series of guidelines covering architecture, site layout, signage, and landscaping. And based on the extensive reliance of the pattern book on the work of the Route 12 Border Planning Council, which was the vision for any future development along the border, wherever it might go, that directly addresses the issue of compatibility in the sense that the whole purpose of that group's work was to ensure that any future development did not negatively impact surrounding areas.
They're just talking about the Route 12 corridor, though, not the neighborhoods behind. So thank you, Erica. If the engineer could come out from one of the villages. Hi, thank you. Can you state your name?
Andrea Croft.
Hi. Are you familiar with the soil and water report on this property? going to get into any specifics except that it's about 70% hydric soils there.
Yes.
And those hydric soils, it's not recommended for, let me put it the other way. Commercial should be very limited. Depth to saturate zone shrink swell. Can you tell us what that means?
The hydric soils and soils that include hydric inclusions are basically, in layman's terms, wet soils. They are more clay soils. So in your soil reports, when they see soils like that come up, they will state that they are restricted for certain types of development because of the water and the structure of them.
So that would be poorly suited or unsuitable soils for a multi-story commercial building is basically, in layman's terms, what they're saying.
Typically, or it would cost a lot more to construct on them.
And what would you have to do to construct some larger commercial building on that in terms of?
I am not a structural engineer.
Okay.
So I cannot really.
But we do also know that it's not advised to have residences with basements there either, right?
If you have residents with basements and wet soils, you have more risk for water and pressure on the basement walls. Yeah.
Thank you. I think I'm done. Thank you.
Break first. You want to take a break? 6:30. You said 6:30. Okay. We'll take a 10-minute break.
And we're taking a comfort break, and we'll return in about 10 minutes.
That's what's giving us the feedback. And so if you can talk with your mouth literally eating, pretend like you're a rock star, because I see them literally shoving it down their throat. Talk that way, then we will help cut down on the feedback. Okay, our next commissioner is Greg.
Can you hear me all right in the back?
Yes.
A question for staff. There's currently an area that has been requested to be annexed by North Barrington. These are residents in the immediate area of the subject property. And the question is, if that annexation goes through, would that affect staff's analysis of whether or not either Dimucci and or the county are bound by the previous IGAs?
And I'll have to ask you to ask the question again.
The IGA,
on the IGAs.
The IGA only applies if the property is annexed. If this portion of property is annexed, would it affect your analysis of whether or not you're bound by the IGA?
To the extent that at some point in the future, a pending annexation would affect a portion of the property in terms of placing it within one or the other village, we have to consider it at that point in time, and our analysis would have to take that particular section of the property into account.
In the material we received on it, there's a graphic showing the map, and it's a little bit confusing as to what the proposed annexation boundary is and the petitioner's properties. What actually would be annexed? The diagonally lined area, or just the crosshatched areas, which is the petitioner's properties?
I think the county at this point is not, they're not involved in this annexation process. They're not a party to it. So I would suggest that a representative of the applicant be able to provide some details in terms of what the specific contours or the dimensions and the location of that annexation, proposed annexation strip would be.
refer to the map that you have there, so we're talking about the same thing?
Yes. The diagonally lined area as well?
It's a form of annexation using what's called a majority of the owners and electors. So that if you have 7 owners who are within the annexation territory, and 4 of them want the annexation, and the other 3 don't, it can still go through. It's called a forced annexation. The area that you see there that's just diagonal lines is the Dimucci. The area with the crosses are individuals in Valentine Manor who have elected to initiate a lawsuit to try to force part of the Dimucci property into North Barrington. Now, I'm not the litigator that is handling this, but I can tell you one thing. The infamous boundary agreement that nobody is following, not the villages, indicates that all jurisdiction, all planning jurisdiction, is ceded to Hawthorne Woods. This action alone is a violation of the boundary agreement. So all this touting of the boundary agreement and reliance, what we see is one village totally, and I get it, it's not the village, but if the village says, okay, we will accept that annexation, they have violated the boundary agreement. North Barrington, in their comprehensive plan, doesn't even show this property because jurisdiction has been ceded to Hawthorne Woods under the boundary agreement. And Hawthorne Woods' comprehensive plan shows what we're requesting, as does the Baycott plan and the Route 12 corridor plan. All say commercial.
I'm sorry to interrupt, but again, to answer Carol, I am one of the litigators in that case, and I respect what he said, so I'd just like to add some additional information. Thank you. That matter is scheduled again before the court on August 1st. And while it's claimed to be a forced annexation, it's a different type of annexation that I normally consider as a forced annexation. Well, it's true if you have the majority of property owners and electors who want to annex a certain territory, they may. But what happens, and I will tell you that the state attorney's office has been to every court proceeding that I've been to in this case, so the county is certainly well aware of the proceedings of this case. What will happen then is that if certain procedural requirements have been fulfilled, notice, properly identifying the property, then the court submits that question to the jurisdiction of that community, in this case, to North Barrington. And the village and the corporate authorities of North Barrington then will decide whether or not they want to annex that property or not. If they decide, I don't know whether they will or not, but if they do decide to annex that property, then that property becomes effectively part of North Barrington. Whether that has an effect on the intergovernmental agreement between Hawthorne Woods and North Barrington, with all due respect, is the problem between those two communities. But as a result, that property is no longer in the county of Lake. And as we spoke about before, as I mentioned before, pending those proceedings in court, I don't know how you can consider this matter. Because in a matter of 30 days or 45 days, whenever the corporate authorities in North Barrington would take this up as an issue before their board, the property is now in Lake County, is no longer in Lake County.
Now, you are talking more, making a presentation. You're not answering this question because you already have answered it.
I want to add some clarification to Mr. Iden's response in that he wasn't part of the litigation, and the commissioner also has allowed me to address this. So thank you for the opportunity.
Thank you.
And brief response, please. I agree with the statements. The problem is when we hit the part that when it's submitted, if it's submitted, the judge may throw the annexation out. If it's submitted to the corporate authorities for consideration, the second they say, yes, we will accept that annexation, they have violated the boundary agreement. And yes, it's between Hawthorne Woods and North Barrington. The county is not a party, as we previously described. But all of this it's an illusion, it's a fiction. Nobody's followed it. And this is a clear example that if North Barrington goes ahead this way, they had no intention of ever following it anyway. So this is not a foregone conclusion. There is no injunction against these proceedings. There is every possibility that the case would be dismissed. It's a sideshow and shouldn't affect these proceedings.
Okay, thank you. Question for the two municipalities, and pick the people that you want to talk to the question. What specific, and I mean specific, services are you anticipating that you would be called upon to provide that you would not be receiving any funds for? For example, when we talk about police and fire, well, the fire, both actual firefighting as well as EMT services, that's going to be funded with taxes if this comes into play. But police is not necessarily funded except through the sheriff's office. And are there services like police where you have specific services you think you would be called upon to provide that you wouldn't be compensated for? This man.
Good evening. I will reply on behalf of the Village of Hawthorne Woods. My name is Pam Newton. I serve as the Chief Operating Officer of that municipality. I believe that the Village of Hawthorne Woods would be called upon for essential life safety issues, health, safety, and welfare issues as a result of a possible construction of an 800,000 square foot facility, regardless of its end use. The municipality of Hawthorne Woods along Old McHenry Road, as many of you may know, is adjacent to this parcel, and our police services are often the first responders even for unincorporated Lake County incidents. As exemplified just this past weekend, where our police services were the first to respond to break into a home, a residential home fire. Obviously, we got there before the Lake County Sheriff, before any fire department or fire districts were there, and life safety is our ultimate concern regardless of whose jurisdiction that incident may lie. The second area of important impact would be our Public Works Department. As some of you may know, we have a full-service Public Works Department that deals with streets and sanitation issues. And I guess I have to regress for a moment because they would be called upon in direct result of the municipalities, the residential homes surrounding this property, whose wells and water service would be affected, as well as drainage that we take care of in our municipality with drainage issues. So we do support the Lake County Stormwater Management Agency, and as such, we are code enforcement officers. So our engineering team would be impacted by such potential development at this site because of the runoff and the implications to our residents who currently coexist with this property. I might mention also this week, it may be of no surprise to any of you sitting here, but our wells have started to run dry in Hawthorne Woods, and specifically, I have reports of wells that are dry and not functioning on Old McHenry Road. So the impact to our community goes well beyond life safety issues. It goes to the municipality and the residents themselves, whose municipal services are called upon for their daily health, safety, and welfare.
Thank you very much.
I'm the president of North Barrington. In answer to your question, Commissioner, yes, our services will be affected. The police will be affected. Although police will be provided on the site in Lake County, generally criminal acts involving the mall do not occur on the site, but there'll be DUIs, criminal acts off the site, accidents, etc. will occur, in which our village and the Village of Hawthorne Woods will be required to respond to. I'm the emergency director of our village, And I know a little bit about our fire department. It's not quite accurate when you say that the fire will be supported by the taxes which will go to the Wakanda Fire Department. These fire departments, Wakanda, Lake Zurich, which services us, and Barrington, which services us, all share in their co-responsibility. If there's a fire, they call other municipalities into it. Currently, Lake Zurich has 3 firehouses staffed by 1 person at one time. If they have a fire, they can send out a fire truck. If they have a paramedic, they can send out a paramedic, but they can't send out both at the same time. They all have to staff their firehouses with more individuals, and they will receive no income whatsoever from this property, and neither will any of the villages. In terms of pollution and our cost of our community, pollution cost of this type, if the water drainage is not carefully monitored, and the Flint Creek area, the Miller Road area, which the county is currently considering a landmass to build up, if that doesn't work, and the Flint Creek community area floods, 50% of our village is on well and septic, and 15% of it could lose their septic and then could lose their well. If that occurs, and I have to RegCo 50 homes because of the flooding, the county will not pay us any, will not support us in this endeavor. They'll probably just say to me, put a sewer in. Thank you.
Thank you.
In terms of that sewer, by the way, we did pay $5.9 million for it. And they did not tell us they were going to use it for this property. We don't want to do it twice.
Since the information was just brought up, may I address it briefly? The $5.9 million item, I think, is referring to the sewer extension.
It's really not pertinent to my question.
Okay.
Thank you.
Although I would like some time to respond to all the questions that were addressed to others and not to us.
In the Dimucci presentation, you talked about if the water doesn't come in as planned, talking about potential use of alternative sources or non-potable water. Was there any discussion with the Fire Protection District on what that, how extensive that might have to be?
I believe the issue relates to water. Is there water storage and volume available so that the fire district, that is not an issue that we have gotten to because again, it's the same thing. We don't know the volume that's required. That is part of the planning of the ultimate system, whether it's by wells or by more likely potable water from Lake Zurich. But we know we have to meet requirements. There are life safety requirements that I'm sure we could not escape and still have approval for a final plan.
Thank you. Is the lady from storm management, the engineer, still here? Oh, okay. Yeah, I think I went stormwater management then.
Guy or girl?
We have a choice.
The comment that was made in relation to the weight of large multi-story buildings and so forth on the subject property, would just the weight itself have an effect on basements and surrounding homes?
So the earlier conversation was the hydric soils, the wet soils, putting in foundations and other structures in that soil.
Right.
Those soils are the existing conditions out there. There's no regulation that says when you develop, those soils must remain in situ and they cannot be moved around. Typically, areas are excavated, poor structural soils are removed, and if there's predominantly poor soils everywhere, construction practices do allow wider footings, deeper caissons to, bear those heavier loads in those poor suited soils. If you have the clay type soils, that is good for structural, can be compacted, then your footings and caissons are not as large. In those poor areas, the cost of construction goes up, either to build a larger footing, or those soils are removed and clay type soils are brought in and compacted. So it's all relative to the cost of construction. And with regard to basements, yeah, if there's basements that are built in areas that have wet soils, that saturated soil will create a hydrostatic pressure and put more weight on the wall. So a foundation wall, which is typically 8 inches, might have to be 12 inches because you're going to have more force on it. Also, the saturated soil has a water column in there, and your sump pumps will be running more often. So that's just, you have to accommodate that with design. Typically, a geotechnical engineer would come out and do soil borings, monitor the water, determine at the design stage what type of construction practices need to be implemented.
Thank you very much. Eric, this is, in my 10 years, this is the first time I've seen a distinction made between a preliminary developmental plan and a final developmental plan. We always say that.
The ordinance, the Lake County Unified Development Ordinance, provides for really 2 stages of review: the preliminary development plan stage and the final development plan stage. Typically, those stages for a less complex development might occur within a shorter time frame from each other. Larger, more complex developments will involve a greater length of time between the preliminary development plan stage and the final development plan stage. But yes, all PUDs have both stages embedded in them.
Can I ask when that ordinance was passed? Is that an old one? We've always had it.
The Lake County Unified Development Ordinance was adopted in April of 2000, April 11, 2000, so it's 12 years old.
Do other counties or other governmental units follow a similar, allow that similarly?
You'll see a range of different approaches to planning and development process. A lot of communities involve a 2-stage process, preliminary and then final development plan design. Some communities have a singular process where it's 1 stage. It just depends on the community. The county, since 2000, has instituted a 2-stage process where you have the conceptual plan review and design review at stage 1, and then the final details identified and addressed at the final stage.
Well, as we saw tonight, it leads to real problems when you start trying to make judgments about what the effects will be if you don't know what the final product is going to be. And I may just come and sit in on the ZBA meetings just for amusement.
Right. There'll be an opportunity definitely for getting into those kinds of details at the ZBA stage. Or experts who have the opportunity to be consulted and provide testimony, sworn testimony in terms of potential impacts on the site and on surrounding properties and how those impacts can be mitigated. As I said before, some conditions are very precisely defined already, or some conditions and some issues are precisely defined and anticipated. Some will have to be addressed at the final development plan stage. That doesn't include the process from this point in time from addressing in anticipation of those types of issues to building conditions that address them.
Thank you. Back to you, Mr. Chairman.
Okay, thanks, Ray. Larry.
I'm Larry Foley from the radio. Go ahead, Larry.
I understand from the emails clearly that you're going to abstain. Are you still abstaining from voting?
I'm going to get to that right now. I'm going to get to that right now.
Oh, okay, because if you are, then I'd like to ask the chairman of the commission's like the rules.
I'm sorry.
Make your statement.
Well, anyway, my name's Larry Falvey. I'm from Libertyville Township in Mattel. I plan to abstain from my vote tonight. I'd like to explain that. I was out on trial for the last 2 weeks in Cleveland, 3 weeks, and so I wasn't able to come to either of the main meetings. I did make a good faith attempt to read or listen to all the audio files, but it's an overwhelming amount of material. We were provided with some great written notes, but after going through the audio files, it really just doesn't do justice, I think. And between the written comments and between the audio files that I did get to, I can't, in good faith, I think, cast a vote tonight. However, I do have a couple questions. I don't think I'd give up my right to ask some questions. And frankly, in the event that we don't get to a vote tonight, we may be here again, and I may be able to catch up. So one never knows.
I agree. I think you should be able to ask all the questions.
You asked most of the good ones, Rainey, so.
There's another member of our commission who has refused herself, Nancy Burgess-Schrum, who is not allowed to ask questions, and I'm just wondering if you're going to ask questions, and then you should allow her to ask questions. That's my only.
Well, I'm not recusing myself, I'm abstaining.
Oh, I understand.
So, there's a
But either way, you're not voting.
I'm not planning to vote today. Right. So, okay, couple questions. First, just to follow up on something that Craig said. I think, Eric, we're troubled a little bit by the whole preliminary concept and approval issue. And, I sympathize with the developer or the property owner who, I can understand why they want to sort of jumpstart the process a little bit and get some degree of certainty with respect to what may be allowed on this property, because anybody coming and looking to actually build something on this property, is going to be facing going through this whole process. And obviously, if they want to try to encourage development, the more they can do to kind of invest the property, the better. So I can understand that. But I think the problem that at least a few of us seem to see, and certainly many members of the public, based on the comments I did have an opportunity to review, are really concerned about the fact that we are being asked to make a recommendation at the preliminary stage. And I understand that there's conditions that have been proposed and other things, but it would seem to me that as far as the recommendation of the RPC and the ZBA, why is it that we're being asked to make a recommendation at the preliminary stage instead of the final stage when we actually have a site plan and something actually being proposed concretely? In other words, I can understand why we have the two-stage process, but it seems to me that we're being asked for all the recommendations be put in place before we have the actual site plan. So I wanted you to see your comments on that.
That's a good question. The proposal at the end is a combination of different requests, one being a rezoning request. There is no requirement for a precise plan in the course of a request for rezoning action that the applicant could have easily proposed a straight rezoning without an accompanying preliminary development plan and ultimately a conditional use permit request. The role of the RPC, again, is to look at the broad themes of potential development, significance of development impact, to the extent that we're at the preliminary development plan stage and not every detail is yet known about what ultimately will be placed on the site. It still doesn't preclude you as a body from raising certain issues that are to be addressed in more detail when we get to the ZBA stage to anticipate, identify, and ultimately craft conditions that would address any potential impacts in the future. Again, as I said before, the preliminary development plan we have in front of us is not without content. It's not without substance. There are numerous restrictions embedded in that plan itself, the plan document, as well as the accompanying pattern book. The development proposal is constrained under the application by...
Eric, can you speak more into the mic because that's what's giving us our feedback.
I see. The development proposal is constrained under the application location by setbacks along the property lines. It's constrained by height limitations. It's constrained by a series of requirements in terms of buffering and lighting. Some of these things are performance-based, performance standard-based. Whatever happens on the site, it has to meet a certain foot candle threshold, right? or be less bright. So the plan proposal does have detail that addresses impacts, and I think that it is germane to the commission to make a recommendation at this stage. Again, looking at the RPC's broad regional role and looking at development of regional significance.
So let's say that this goes through the county board, approves it at the preliminary stage. Does this development come back to the RPC at the final stage for the same process, or is once, if the board recommends it and it's compatible, is that the last we ever see of it?
The ordinance provides that at the preliminary development plan stage, the Regional Plan Commission will get involved in the review at the outset. At the final development plan stage, the reviewing body is the county board's planning, building, and zoning committee, which per the ordinance can conduct a series of information meetings. So the Regional Plan Commission is not per se directly involved in the final development plan review stage. So that stage is designed to ensure that all the conditions that have been raised in the preliminary stage of planning.
All right, but bottom line, this is our only bite at the apple.
This is the Regional Plan Commission's official part of the process. You have an opportunity to participate as citizens at any point in the process.
Two other questions. I won't be nearly as long as some of you will maybe. We'll find out. There was a lot of discussion in the comments that I reviewed about the Hawthorne Comprehensive Plan, I think, and I think the petitioner made a strong point about it being compatible with that plan. And then some other comments that I listened to seem to suggest that perhaps there was a mistake in the plan, and I'm speaking specifically about the issue of whether or not the plan contemplated 25 acres of commercial development on the property or 50 acres of commercial development. So I wanted to see if you could address that, and then maybe we'd ask Pam or somebody from Hawthorne Woods to address that.
Well, the intergovernmental agreement predates the Hawthorne Woods comprehensive plan that was referred to in the presentations at the outset by years. The 2004 Hawthorne Woods comp plan was the most recent articulation by the village of the development potential for that site, should it develop in the village of Hawthorne Woods. And that plan identifies 50 acres of development, commercial, and the balance of the site in residential. The commercial component that's proposed in the Hawthorne Woods comp plan is consistent with this particular application's commercial proposal. However, the difference there is that the balance of the site being residential in the comp plan is inconsistent with the proposal here for the balance of the site in permanent open space.
Okay, so if I understand what you're saying, the Hawthorne Woods comprehensive plan shows 50 acres worth of development, but only 25 of that is commercial, and the Dimucci property plan is 50 acres.
Now, the 2004 comprehensive plan of Hawthorne Woods, in my understanding, calls for 50 acres maximum commercial, with the balance of the site in a mixture of residential types. This particular proposal here calls for a maximum of 53 acres of potential commercial. So it's roughly compatible with the size of commercial scale that's identified in the Hawthorne Woods comp plan.
Okay. Pam, do you want an equal time?
Thank you. The Village of Hawthorne Woods did try to state the position, but unfortunately it was very hard to do in 3 minutes.
I noticed that.
The execution of the IGA between our two municipalities in its most current form, which is dated August of 2002, details that no more than 25 acres of the site shall be developed pursuant to a planned unit development as retail development subject to the permitted uses. Such retail development is located very site-specifically on the southwesterly portion of the site. The confusion herein, as you accurately state, is a Scrivener's error. In order to substantiate that, the Village of Hawthorne Woods did retain Al Maiden, who was the planner at that time, to once again look over our comprehensive plan that, as was accurately reported, was last updated in 2004. In that update, it was a limited comprehensive plan update, and so therefore the verbiage never got updated. There were certain parts of that plan that got updated in 2004, and unfortunately the ordinance that had been passed with that verbiage statement of 25 acres never got entered into that 2004 plan. So Al Maiden, at our request, within the last 2 months, did measure the subject site in the comp plan that was shown here to everyone, and that measurement shows 25 acres or less depicted in pictorial on that site. It does not show a 50-acre subject property for retail location. In his professional opinion, Al Maiden has written, and I believe we've turned that in as evidence, that his responsibility during that comprehensive plan update simply forgot to reflect the ordinances on file with the narrative of the 2004 comprehensive plan.
Thanks, ma'am. Yes. Yes, go ahead.
I just want to read briefly from that plan. To consider proposals for limited commercial development for the mixed-use area shown on the plan located north of Valentine Manor, south of Old McHenry Road, east of Route 12. That's the Dimucci's. The site, which is over 100 acres in size, lies in unincorporated Lake County, provided that an acceptable alternative to conventional septic system waste disposal can be achieved, which is what we now have, then the village envisions that up to 50 acres of the site could be developed for commercial use. It is envisioned that the residential development will be at a density that is consistent with that of surrounding development. I don't know how you make that mistake when you go out of your way to say, all right, if we can solve the sewer problem, we'll go to 50 acres. I mean, the other plan didn't say, well, it's 25 acres, but only if you have sewer. This went out of its way to say we can increase it if we have sewer. And you look at the Baycock plan, it shows 100% of the property as commercial. Now, the head of Baycock stood up and said, well, we really didn't mean the whole thing, but substantially.
You're talking beyond the scope of the question.
Okay, thank you.
Thank you. Last question, since I stole before. Eric, there was also a lot of comments that I listened to that raised the concern of the need for the commercial development in the sense that we've got the little mall, we've got all these other retail areas. How much is too much? How utilized are these other retail spaces? And I guess my question to you, and I would invite maybe Mr. Brown or someone to give sort of the opposing opinion. What, in your opinion, is sort of the purview of the RPC to consider the success, if you will, or the commercialization in the area in terms of how successful it is, or is there a commercial need? Because I'm a little concerned about the idea of the RPC sort of deciding that it's going to be the judge of who gets to develop commercially based on the success of other commercial developments in the area. It would seem to me that if something is compatible with the plan, it's compatible. But if the mall up the road isn't doing so well, why does that mean that the Dimucci's, for example, have to wait until there would be a demonstrated need for commercial development? So I do find that personally troubling, and I wanted to see what your thoughts were.
Well, the need for future commercial development is, and I'll sort of preface my remark by saying the need has been essentially for future commercial has been already established by virtue of extensive testimony by both villages and Baycock that this is appropriately designated as a commercial site. How much need and how much commercial would be ultimately cited on this property it's a market function. It's a function of the market demands. How much need exists for commercial in light of these local plans that have already been extensively discussed and stated by village representatives. That they recognize that this is a commercial property, a commercial site for mixed use, for commercial both, but there is a recognized understanding at the local level that this is ultimately destined for commercial development.
So, bottom line, Eric, would you take the viewpoint that it is sort of, an intrinsic function of the property itself as to whether or not it should be commercial, irrespective of the success or non-success of other commercial areas along Route 12?
Again, that's the issue of evaluation of this particular site at this time is to look at it in terms of the trend of development, the compatibility of the property, the suitability of it for this intended purpose. The market will drive the details of what's ultimately proposed there at the final development plan stage. It's not a function, as you were wondering, for the RPC to be the judge or jury over how much need is at hand here today. We're also talking about a project that won't develop for several years out.
Right, and I think you would probably say that it's a function of the market. If there's going to be commercial development on this property, it's because the market has determined that it can't be successful, otherwise nobody would build on it.
That's right. The market's going to define ultimately what will be proposed on the site several years hence when the final development is proposed, and the range of uses, the mixture of uses that ultimately comprise the final development plan. This process, at this point in time, simply is to determine whether the property itself is compatible for future commercial development.
Mr. Brown, there you are. I think you had an opposing view as I listened on the audio, so I wanted to give you a chance.
Thank you. I think that the question of need misses the point. The plan calls for what the county wants, what the county sees is in the best interest of the communities and the county as a whole. And focusing only on the need is addressing the individual property rights of a property owner. No one's calling for the RPC to say only when a need is demonstrated should we choose to designate on our plan what the future should be. That's not what's being called for here. What is called for?
Well, I don't think Mr. Wagner is suggesting that that's...
And I'm not disagreeing.
Okay.
But what is called for is a recognition that identifying properties to a considerably larger extent than what need can support has a potential impact on other properties within the county. That by over-zoning, by providing every physically capable site in the county as being red on the map is not in the best interest of a sustainable economic condition, is not in the best interest of the viability of the existing commercial and business properties within the county. Balance is a fundamental part of your plan. And only addressing whether or not there has been a demonstrated need misses the larger question.
Okay, thank you. I'm done with my questions, Mr. Chairman.
Okay, thank you very much, Larry.
I'm going to state that a number of my questions regarding the intergovernmental agreement, commercial trend, plan specificity, annexation, cost impact of services, and groundwater have been addressed. I'm not sure they've been answered to my satisfaction, but I will go through the questions again to spare you all. I would like to put Kurt from SMC up on the spot again. Sorry, Kurt, you're my neutral expert here. I will admit some familiarity with the wetland impact process from my past life, but generally from the planting side, so I'm looking for some clarification from you. Just to kind of clarify, I have a lot of information that I've poured through for many hours. Section 17 gives me a map that indicates 4.19 acres. Section 18 gives me clarification of 2.44 acres. Section 21, which is the actual delineation, lists out at 4.08 acres. So there's even conflicting information within the documents that we've been given. What's the bottom line in terms of SMCs? I know ultimately Army Corps has jurisdiction. Would there be mitigation necessary for these wetland impacts?
Yes, there would. Wetlands grow and shrink. This drought we're experiencing, they're shrinking.
We probably wouldn't find any today, that's right.
Right, so a delineation is, wetlands need to be field delineated, and there's the timing aspects of it. Within the growing season, there's a certain time frame when you need to go out and do this delineation. They're only good for 3 years. So for a development process, that report there, if the final plan would come in 3 years and 4 years, they would need to go back out and redo it because the wetlands have changed. The watershed development ordinance was just amended yesterday by the Lake County Board, and the county board and the Stormwater Management Commission unanimously approved a lowering of the wetland mitigation threshold. The regulations used to allow a larger footprint of wetlands to be impacted and not mitigated. And the new regulations have now lowered that threshold. So any impacts greater than 1/10 of 1 acre require mitigation. So the wetlands you're reading, 4 acres, 3 acres, they're already going to be tripping that threshold. They will all need to be mitigated, and then some. There's a multiplier effect.
Right.
So it's not a 1-to-1 ratio. Based on the quality of the wetlands out there, there's going to be at least a 1.5-to-1 mitigation for those wetlands within the watershed. We don't want to offshore wetlands out to different watersheds, so they need to stay within the watershed. It's part of the regulations.
Thank you for clarifying the mitigation requirement. One of my other questions relates to concerns about the water quality impact. Would there be jurisdiction by SMC relating to any detention facilities and vegetative buffers and the management of those buffers?
There would. Water quality is, there's 2 parts to it. There's the construction water quality, the soil erosion and sediment control requirements during construction when debris is being dug up, excavations happening, and soil is being moved around. There has to be adequate soil erosion stabilization measures like silt fences, sediment basins, different types of practices during construction. And then for post-construction, there's requirements for water quality. There's an additional requirement for what's called hydrocarbons, and those are your oils and greases that are typically found in parking lots. Once you exceed 25 parking spaces, you've tripped that threshold, and you have to have an effective oil, grease, hydrocarbon removal technology, and there's different ways of doing that. Open space is an effective treatment where you let the vegetation filter out those pollutants and debris. The site in its existing state right now is agriculture. It's all exposed. It's not stabilized. Agriculture is one of the largest polluters of water quality with fertilizers, pesticides, and just bare dirt going down the line. When you stabilize a site, typically we prefer, and it is a requirement, to put in native vegetation inside the detention zones. And the native vegetation has deep roots that penetrate the soil and really lock it down, filter out pollutants. But we will have a different type of pollutant from parking lots, and that's the oil and grease. So the pesticides and fertilizers aren't necessarily the main pollutant loading. It's a different
material.
It's a different material.
You mentioned earlier in one of your previous answers the removal of hydric soils or adjustment of hydric soils, which, again, based on the maps, certainly seems to impact a significant portion of the site. I'm coming up with over 48% hydric inclusions, and most of those would still be impacted even from the basic conceptual plan that we've shown. Those hydric soils have a storage capacity, am I correct, for retaining stormwater? Is that storage capacity lost if those soils are impacted or moved? And is that factored into the equation of detention they have to provide on site?
They are. There was a floodplain study that was a preliminary study that showed the depressional areas within the site, and I don't have that quantity, but they did quantify, I think, half a dozen of these pocketed areas that hold stormwater. And based on the types of soils, there's an infiltration rate in that. So water can infiltrate into the ground based on those types of soils. The accumulation of all of those pockets equals some volume. That volume has to be mitigated in addition to the detention volume. So whatever the site's detention storage volume is, all that extra volume for those pockets needs to be stacked on top of the detention. So you can't.
It's a cumulative issue.
It's cumulative. They cannot coincide within the same zone. So you're not only required to put in the detention volume for the development, but for the existing condition, the site has those storage features. Those have to be mitigated as well.
Thank you. My last question for you then is, within wetland mitigation and Army Corps requirements, there's a 5-year management requirement post-implementation. For SMC, what's the long-term management requirements? What assurance do we have that those buffer areas and water quality controls are going to be cared for in perpetuity?
Yeah, just to clarify, the 5-year maintenance and monitoring is for wetland
mitigation.
For wetland creation. So if you're doing mitigation on your site and you're creating wetlands, it take a while to take hold. They're not an overnight process, but there's other ways to mitigate wetlands. There's mitigation banks that you can purchase credits from. There's the on-site mitigation. So the 5-year requirement would be for on-site mitigation, and the Army Corps and the Lake County Stormwater Management Commission for the isolated wetlands, we pretty much have the same requirements. If they do on-site mitigation, there would be a 5-year maintenance and monitoring requirement to actually attain a higher floristic quality inventory. It's an FQI value. They have to increase the value of the vegetative aspects, and the wetlands have to perform in a better than the original condition.
Those assurances are in place relating to this property.
Those are regulated development standards, which would be part of the permit issue that typically have no control until a permit comes in for design.
Thank you. My next question is for Eric. I went through my notes from the June 7th public comment meeting and tallied up, obviously, a lot of comments about the impacts and so forth. But 9 of the 25 speakers addressed specifically the fundamental loss of trust in the county planning department if the county pursues this in what the public perceives as a violation of the IGA. Whether it is or not, it still remained clearly the public perception of that. Do you have a concern about the loss of trust from the public for county planning if this proceeds?
Absolutely not. I think that the county has the resources at its disposal to manage development on a large scale. It is one of the largest local governments in the region. It has capable staff in all departments that participate jointly in the review of development proposals to monitor development as it's occurring, and then long-term monitor the condition of properties. And the issue of public trust in the institution is a function of how the institution carries out those responsibilities. So as we proceed through this process, and as the proposal makes its way through the appeals, public hearing process, and beyond, we'll obviously give the public as I've made before, that the applicant here owns property in the unincorporated area. It's the applicant's right to propose development within the unincorporated area. It's our legal responsibility to conduct a review of that proposal. We don't have the authority to turn it away. We have the responsibility to proceed with the development review process. The county is not bound by signatory to the intergovernmental agreement between the two villages. The applicant came to us, and so we have to honor that. That's if we were to fail to do so, that's an abuse of public trust.
What side?
Well, I guess being new to the RPC puts me at the bottom of the list, so most of the questions have been already asked. I had quite a few on the IGA as well as the traffic. The one piece is based on the one question I had is based on the water. I know it's been mentioned here in standard 4 and 5 that you need to be able to supply adequate public facilities, and I know the water was brought up that 2018 seems to be this number that's floating around. Is there a plan? Do we know where that is for public water as opposed to having to set up a, how do you stay in here, the private well, which I know we've already heard quite a few times we're running low at this point? I don't know if that's a question for you guys or...
As to the agreement between the applicant and the villages, or best suited to address that.
Just to reiterate on the agreement, anything prohibiting the owner from obtaining water directly from Lake Zurich, the agreement that does that expires in 2018. Hence, at that date, we could receive water through a pipe from Lake Zurich. Prior to that time, in our agreement with Lake Zurich, we have the right to service the property with wells. Now, just to give you an example, I don't know if all of you know, I think it's Liberty Lakes and Concorde Orchard and all that development is by Gilmer and Fairfield. But at that time, the same concern came. Everybody around there was on pretty much shallow wells, some people even down to 350 feet. And I'm not a scientist, but I'm just going to tell you what I know. There are various layers where water is available, and in between them are what are called aquatards. They're basically like you can see it as a steel or a plastic wall separating the aquifers. So you can go to various aquifer levels and get water that nobody else is in. It requires a lot of studies. And you drill test wells. And you go down and you see, okay, there's water at this level, let's go a little deeper and just see how deep this thing is. What kind of volume can we get? Can we pump out enough into a storage tank, like a surface tank or an under parking lot tank or whatever, when the fire department comes, is there enough water there in gallons per minute and in total volume? You have to do those kinds of studies to figure this out. I can't imagine a situation where we just come along and dig a 200-foot well and just start siphoning water off at that point. We're not going to be allowed to. We're going to be required to do various studies. The EPA, IPA keeps well logs. It knows all the depths of the wells within the drawdown area, meaning that if we pull water out of a certain area, how does that affect drawdown on other wells? You go through all that stuff in the engineering process. If you're going to draw down all the other wells, you're not going to be able to do what you're not going to want to do, because you don't want to hear that you're ruining somebody else's well. And maybe that's out of the goodness of your heart, or maybe it's because you don't want your development tainted by people always writing angry things about it. But you can go through various aquatards and end up in a very strong aquifer that can support a lot of homes, but they don't because they're too deep. But for a project of this magnitude, if it's as big as everybody describes, which I'm not sure where the mall and all that stuff came from, but if there's a high demand for water, you can go to a high demand or a high volume aquifer and be entirely separated from anybody else's well within a large radius.
So your first comment, you said the agreement is over in 2018, or
No, The agreement states that until 2018, unless Hawthorne Woods says, okay, we'll release provisions of the boundary agreement with Lake Zurich. Until that time, we can have a well. After that agreement between Hawthorne Woods and Lake Zurich expires. At that time, Lake Zurich has the obligation to supply us water, and we have the obligation to accept it. In fact, our water lines have to be designed so that they can be easily connected.
Okay. That was where my confusion was. Go ahead. Go ahead.
Can you hear me?
Lift it up more, Dan. That's real close to you.
All right, so once again, Dan Shapiro from Hawthorne Woods. I want to address the utilities. I'd first like to address sewer. As some of you may know, there was some...
That was not the question. The question now has to do with water. I will let you speak only at water.
Thank you, Chairman. Commissioner Magg, standard question.
I was just really concerned about the water.
All right, then I'd like to address that.
Okay, go ahead.
If you look at the application in Chapter 15, there's the executed agreement between Lake Zurich for utility service, and by that I mean water. And it states that Hawthorne Woods has the right to provide water service to the Dimucci property in that agreement. It's Hawthorne Woods water. And that agreement was signed in 1980 because all the parties agreed that water and sewer was provided by Hawthorne Woods. The parties also agreed that the Dimucci property was in Hawthorne Woods' jurisdictional boundary area. Now, I don't know how this application can go forward with respect to provision of utilities when those utilities, and in this case we're talking just about water, is under the jurisdiction and control of the Village of Hawthorne Woods. If at a later time you'd like me to address sewer, I'd be happy.
Thank you.
No. I can make a mistake to let the other attorney answer speak because that was a presentation. We are only responding to questions that we are asking you, and if Michael has a question that may be pertaining to you, then you will have the right to answer, but you are not to give more testimony.
I think I pretty much have what I need. So.
Oh, come on!
The next piece I had was based on this pattern book, and I know there have been questions regarding the wording in there. How, and not seeing one of these before, how written in stone are those, I guess? If we were to go ahead and say, yeah, we're going to approve this, here's this pattern book, we've all seen it, it's huge. How much could that change between now and the final stages?
The pattern book is being proposed as a condition of approval at the preliminary stage, and in the format the pattern book takes, all of the elements that are within that would have to be addressed by the final development plan. Now, if in the course of the testimony and the deliberations of the zoning board of appeals, certain ideas, certain design concepts that require further elaboration, or new ideas that are brought into discussion based on the testimony, those additional elements can be incorporated into the pattern book through the deliberation process as a condition of approval. The idea is that no development could occur on that property, get approval at the final development plan stage unless it complies with all of those elements in the applicant's pattern book. And so that's the mechanism, the condition use permit condition mechanism to ensure that any future development would comply with those design conditions.
It can obviously change between now and
if the ZBA feels that it's appropriate to tweak and to add, to refine, then it's their purview to make that recommendation ultimately to the county board. The county board could act on that request.
That's all I have at this point.
Thank you. Cindy, you're next.
Mr. Chairman, I'm Jackie Cunningham.
I'm sorry. Okay, Jackie.
I have no comment at this time.
Okay, thank you. And then, Terry.
Okay, thank you, Mr. Chairman. Almost all of the important questions that I have have been asked and answered, but I do still have a couple. I addressed it personally, I guess, to the Dimuccis, and more of in general nature. I understand that any plans that we see are preliminary for the point of discussion, but being personally a big advocate for open space, do you have any vision or plans or future intentions for the use and access to those open space on this plan by the public?
Well, we didn't envision active use only because a lot of times that's discouraged, because sometimes it requires lighting at night, that sort of thing. What we did envision was passive use, landscaping, aesthetic type stuff, detention that could be made to be attractive, and with the wetland plantings and those sort of things that have been discussed here. There may or may not be walking trails. I mean, that's an issue that the planners have to discuss. Our preference originally was simply to make it passive recreation and aesthetics, and we thought that that would be better received than some kind of active use, which in some cases is not acceptable to surrounding landowners.
That's a reasonable response, I think. The next question, everybody talks about 800,000, and Mark, if you want to see up there, I think it's addressed to you. Everybody keeps saying 100,000, and I've read several things on behalf of the Dimuccis to say they don't know where that number comes from. Can you address that? And then Eric, I'm going to ask you to address it too.
Yeah, I can. 800,000 square feet seems to be a projection of what the maximum amount of square footage could be based upon uses that were selected that would have the highest amount of floor area and still be able to accomplish all the other things that you need to do, such as parking, detention, that sort of thing. It's kind of a theoretical maximum. It seems like we're fighting the whole Tallman Mall thing all over again. There's no mention of a mall. There is a mention of a maximum square footage, which is an estimate based on what uses in perfect combination could create the greatest floor area. The concept that this is all retail, that it's 8 stories, I would love to see where all that comes from, because it's entirely manufactured. There is no intent to prejudge the size and say it's 800,000. What we want to do is...
Do you actually have a number in mind?
Well, no, because it's, again, it's all dependent on the use. You've got a mixed use, which many of these things are. The floor area would be yielded a lot by the land plan and the parking demands that are required to support that on the restricted space that we've agreed to. Remember, this is really a rezone for us. And the county came along and said, we can't support it unless we put restrictions on it, to which we voluntarily have agreed. So I can't tell you today that it's 800,000 or 300,000, but I'm fairly convinced that under the bulk regulations, the GC ordinance, there wouldn't be any way you could get beyond 800,000. So,
and I think that answers my question on behalf of you guys.
Yeah.
If I may, Eric, can you tell us how we got to that number, 800,000?
That number was identified in the application, and one that, again, and I won't really add much to Mr. Wright's comments, but that's a maximum, theoretical maximum. The likelihood of it going to that degree of floor area remains to be seen. In fact, there's every opportunity for the zoning board of appeals to take a look at what maybe any
Next question then for staff, Eric, if you want to, or hand it off if you like. There's a number of taxing bodies involved, not just the municipalities, which I think you pretty much know where they stand, but without necessarily repeating conversations, as I'm not looking for hearsay testimony, but have the other taxing bodies, the township, the fire district, the school districts, had a seat at the table for any of these discussions?
The various taxing districts have an opportunity to participate in the process and to make a comment. We haven't received any formal kind of recommendations from any of those. They would ultimately be impacted by any commercial development property because commercial development, any development affects the tax base. Right now it's an agricultural property. It's assessed agriculturally. Any future development of the site in commercial would have an effect on the equalized assessed value of the property, and ultimately that has an effect on the amount of money that goes into the taxing districts, be it the fire protection district, district 95, Lake Church School District, library district, and so forth.
And not implying that it's staff's responsibility to, but did you reach out to those districts? And I think you indicated that they didn't come to any open forums, but
they are notified at the CDA stage and any review like this. And so it's our understanding that we've had at least a formal conversation with some of these folks. They'll have an opportunity to participate further later on.
okay. My last question, I think, has to do again with local support services, in particular emergency management, whether it's fire, rescue, or law enforcement. I am aware that Wakanda is the fire district. Do they also supply the rescue support?
It's fire protection, EMT services, and so forth. But it's also a function of mutual aid as well.
Well, and that's the next where I was going. I mean, in mutual aid, as far as law enforcement is concerned, does the sheriff have a substation nearby, or are they going to have respond to calls out of Waukegan?
I'm not aware of the nearest location of a substation. We do have a presence in that part of the county. We actually provide contract services to municipalities in the area, including North Barrington. We do have a patrol presence there. If at some point in time additional facilities, substations are necessary in that area, we can look at providing them. In fact, work with our mutual aid partners at the village level in the area, both in terms of fire protection and so forth, to address any potential issues down the line.
Okay.
Mr. Chairman, well, I saved myself for last for a very specific reason, because almost everything that I had on my question sheet has been asked. The one thing, though, I want to talk a little bit about, and that's to the developer. In light of the economy that we have right now, you're asking for a land unit development, and that generally lasts, I believe it's 2 years or 3 years, and you're asking for an extension. They'll bring it out to be 5 years. What will happen if at the end of 5 years you have not been able to find an appropriate developer to develop this? What is your recourse at that point?
I guess my response is I hope it doesn't happen, but we've all been suffering through a quite lengthy recession, depression, some call it. We know that a lot of the markets, the real property markets, be they vacant, residential, commercial, what have you, are not all that active at this point. We also know, but we expect them to be. I mean, I hope this country recovers. But I also have to know that this is not your typical project. It's not really a project. It is not your typical procedure where you come in, you get an approval, and then it's easy to put something together because it's a cookie cutter strip center. This requires identification, first of all, and it's got to be a quality buyer. The universe is small because there'll be a lot of restrictions on this property which we're going to voluntarily accept, and that limits the marketplace to the higher quality. All right, so that's number one. Find them and go through the contract process. their contracts become contingent upon their future approvals. So they first have to design them then while they're under contract, which for something like this takes a lot of work. And once you design it, you have to bring it through the process. And as you can see from this process, it isn't something you do quickly. Take a while. When you're done, you have to do all your construction drawings. This is no different, by the way, than the Deer Park process that we engaged in. But they were lucky. They had tenants. There's a concept called co-tenancy here, where one tenant, like an anchor, says, I'll come in here, but you gotta have Gap, and Restoration Hardware, and 5 other guys. And Restoration Hardware says, yeah, but I'll come in here, but you gotta have Barnes & Noble and this kind of restaurant. That takes a lot of putting it together. And so in Deer Park's case, it was easy because people were trying to bid at that point in the economy. I was involved in that process, so I know. But given the economy the way it is, and all the things that have to happen in order, we anticipate that while we could likely meet the 5-year, or we likely could not meet the 2-year process, given all that has to go on, and given the fact that everything's got to loosen up. And so we think that for something as regional as this kind of development, it is reasonable to have 5 years. Now, what happens after 5 years? I guess I don't have the answer. It's either everything ends, if that's what the special use permit says, or there's the ability to come in on good cause and ask for an extension. Let's say things are substantially designed, everybody's happy with it, we're up against a time limit. Maybe then the county says, okay, well, we're going where we want to go, and it looks good. You'll get another year. I just can't predict that, but I can tell you why it's more than 2 years.
Eric, would you like to reiterate the process of getting an extension? What do you have to go through?
The process for requesting an extension from the time limit between the preliminary development and the final development plan approval stage is a decision that's made by the County Board of Planning, Building, and Zoning Committee. They address the request directly. They have criteria to consider in making those decisions. So it's the committee's purview for that.
You said the PD&Z?
PD&Z committee, that's correct.
So it would not have to go through RPC or the ZBA?
No, that's just an extension request for the ordinance.
No, I did not recognize you, sir. I did not recognize you. No, I did not ask you a question.
Heavens forbid.
You
don't want anyone to talk.
No.
Citizens aren't allowed to talk.
The pattern book is something that I am very concerned about. And it has been brought up by many of the people here, that there is sort of an area of almost permissiveness in it, and that this is the one thing, when this resolution comes up to vote, I want to make sure that there are some kind of conditions put in there that this becomes very well established and locked in, so there's not a lot of wiggle room. And I want to make sure that the petitioner is aware, and I think I speak pretty much on behalf of the whole commission as far as this pattern book, because this is something new. We're sort of on the cutting edge of developing something, so that I want you to be aware of the fact that permissiveness in the pattern book probably will not be there like it is right now.
We understand. We started somewhere. We started with about 12 Board of Council design, but that was not intended to be necessarily a final product. Okay.
I have not asked him a specific question. I have been advised by State Attorney that you are to respond to direct questions that I ask, and I only asked the petitioner.
You didn't ask him.
Well, my question to him, are you willing to accept very stringent conditions.
Stupid about the questions.
The answer is, as we go through the process, there are going to be a lot of comments. They'll be back. I think we'll end up with a different product. All right, I have one more question. We'll take a brief period of time now for any follow-up questions that anybody has. And let's just start at this end of the table and work our way this way. Or do you? Okay, we'll start with Jordan, since he was the leader.
I'd like to ask the village attorney from North Barrington, who's been such a part of the proceedings here. The last hearing, when Eric just sort of implied that, well, it's not my responsibility to tell people, that it's up to them to discover it, we met with rounds, really ended the discussion for that afternoon, and rightfully so. So I kind of saw some similarity with the gentleman over here. I'm sorry, your name? How do you pronounce your name? Braithwaite. When I asked whether the Dimuccis had been contacted about the intergovernmental agreement, the same type of answer was given, that, well, it was up to them to know what was out there, everybody should have known about it. Just for the purposes of, if nothing else, plausible deniability, why didn't somebody actually call the Dimuccis and tell them, hey, we're discussing your property, you might want to be a part of this?
Let me explain that the entire background of intergovernmental agreements.
I'm asking, why didn't somebody get on the phone and call them? That's my only question.
I cannot say with a certainty one way or another whether or not they did. Someone may have. I did not. That's all I can tell you. I was not the only party to this. The county was involved in this. The county may have called them. The county certainly is in close communication these days, and I don't know if it was then. I do not know whether the interested municipalities, both Hawthorne Woods and North Barrington, engaged in any communication. I do know that one of the people who is an advisor to the Dimucci family, although he has not taken part in this procedure tonight or any other evening, but he's here, was certainly aware of this. Bear in mind that we were talking then, not so much in terms of the Dimucci family, but Taubman. Taubman was the developer, upscale developer, for which this project was proposed. I fully accept the reality that Taubman could not have been involved without knowing about.
Okay, that's what you know about. So, okay.
I cannot answer you correctly.
Okay, the next question I had was for the planner, Tesca. He said that, as I said, once again, we need to look at this. A lot of the questions we've been asking really are not regional in nature. And our focus really is, what is this going to be in the future? What is the most logical thing for us? That's really what the parameters, what's going to happen on Route 12. That really is the focus of our commission. When I asked you to look ahead in your crystal ball, 10 or 15 years out as a planner, what you saw, you told me you couldn't say what it was. Well, if you can't say what it is, could be, how can you say what it won't be? And in other words, you got on it and you said all the things of, well, it's not this and it's not that, we can't have this, it won't be this is the wrong fit for this place. So when I asked you to look ahead and say, well, what is it going to be? For probably your own reasons, you said, oh, I really can't foresee in the future. Again, so if you know what it can't be, or if you don't know what it's going to be, how do you know what it can't be?
Well, you didn't ask that. You asked about land uses, and I responded. What you did ask.
Okay, well, let me say the question again. 10 or 15 years down the road, there's a big piece of property, 100 plus acres. What, as a professional planner, what do you, if it's not this, what is it you see as a planner for that property?
Well, the first thing I would see is the existing comprehensive plans for communities that
are in the immediate vicinity. That would be the first place to look. And those look at mixed uses. They do not look at a single use.
Okay, I'm not an attorney, I'm not an engineer, I'm a marketing guy. Okay, so I look at things in concept and motivation, basically. Okay, I'm driving down Route 12, which, by the way, if people don't think we know this land, I've been coming down here since the 60s down Route 12. Okay, so I know very well, and it's changed a lot. There's a lot of things here that weren't here 40 years ago. Okay, as I'm going down Route 12, assuming there is another use for the Dimucci property, that somehow they are fortunate enough to take a non-performing asset and turn it into something else, what potentially, if I am heading north and I look to my right, what will I see?
I would hope that you see green space. But I think what you're going to see is a mixed use. I think you're going to see not one, not a single use, not a single commercial development over the majority of the site. You would see it developed in a mixed use that was mutually supportive of each other and of the community around it.
Are you comfortable with the assuming it's 25 acres of commercial development as a planner and the impact that you could potentially see? Are you comfortable with 25? In other words, is this just a matter of degree? Are we arguing about 25 or 50? Or are we arguing about this is totally compatible with the regional plan?
I'm not sure.
Okay, let's take it. I've heard figures 25 acres of commercial and I've heard 50 acres. Okay, it seems like there's been some support for 25 acres. Okay, now, for some reason when we get to 50 acres, that's bad.
No, I think
so my question is the problem the matter of degree between 25 and 50?
Well, the first problem is the matter of singularity. There is only one use proposed. It is general commercial. And all of the plans that have been done to date that were reviewed by municipalities were mixed use.
So do you have a problem with the idea? I mean, again, it's a big property. It needs a big plan. There's no doubt. I can certainly understand. To me, that the Dimucci have been very, very genuine in the process. The people who said we don't want this, they're very genuine. The Dimucci's have been very genuine too. Hey, we want to sell the property we have. That's clear.
Yes.
Totally understandable. The idea that they're going to put 50 acres aside as a buffer, as a planner, do you think that, and assuming you've got 25 acres, or you've got 50 acres fronting Route 12 with an entrance on Old McHenry, do you feel that 50-acre buffer is insufficient to the surrounding community?
I don't think it's a 50-acre buffer.
Well, I mean, the circular, essentially they're building fronting Route 12 with an entrance on Old McHenry, and then basically 50 acres around, spread out, proportionally. I don't know what the setback is, but 50 acres in total of a large piece of property will be set aside. Do you feel that's inadequate to the surrounding community? Because I'd like to ask you as a planner, certainly you look at other communities, and I've heard a lot of things about the equestrian. Well, you have to look at what exists, and I look at Gurney Mills, which I'm very familiar with, and remember the days before Gurney Mills when I used to ride my motorcycle way faster than I want to admit down some of the country roads there. There's equestrian all over there. Hunt Club Farms, homes between starting at $500,000 and $1.5 million, with literally if you're a big hitter, you could probably drive a golf ball on the Gurney Mills property. So what in your mind as a planner, if 50 acres total is not enough, what is?
We're all being extraordinarily speculative given that there's no actual plan before you. And the notion that we can guess at what a 50-acre development of type A versus a 50-acre development of type B or C is not a legitimate examination. It isn't, you haven't been given the data for the opportunity.
I understand it, but I understand too. I understand what the Dimuccis are trying to do here. Again, I understand motivation. Essentially, we keep talking about a plan. Okay, really, before the days of zoning, everybody did everything, so just strict zoning. Then they shifted from that to plan use development, to conditional use permit, to exert more control over what they were doing. Okay, so the idea that, well, this has never been done before, I'm not really concerned with, because things evolve. Okay, if I'm understanding the motivation of the Dimuccis correctly, which I feel like I am, essentially they're trying to make a piece of property more attractive. They're just going to a developer, almost like if you're flying to the moon, they're just clearing the tower by being able to say, we can market this property as something you could potentially develop commercially, which is why there's no plan, which is why this could easily take 5-10 years till something happens, because they really, as they're, I'm sure more and more beginning to realize, they're in the beginning stages of something very difficult and very complex. It's going to take a lot of hearings and a lot of money, and whatever developers are going to come in is going to have to go through all of this. Correct? Absolutely. So the idea that there's no plan, to me, doesn't necessarily, I think we're missing the point, because we're not supposed to have a plan. We're supposed to have a concept that this, along Route 12, as a regional planner, is commercial. Is that fair?
No. They have a plan, and so do the municipalities. And they have looked long range, and they have seen what they think is in the best interest of the community as a whole. And this developer is asking for a change of zoning, and inherently saying, ignore the plan, I need the zoning, and until they provide adequate data and explanation of how the impacts would be on a larger area, you haven't been given the rationality to say, we should change our plan.
As a planner, I'm sure certainly worked with our, I'm less than comfortable with the way this whole thing has been handled by all parties. Except that the Dimuccis have been very, very honest with people. Said, we don't want it. Very honest. I understand both of them. I understand their motivation. Okay? I'm saying what they're trying to accomplish. I understand, and they've been very forthright in what they're trying to do. The hired guns are the hired guns. From both sides. You can, if I hired you, you could easily advocate for me developing something else. So if we keep in mind that everybody that got here drives through somebody else's neighborhood, right? They drive, it was formerly Country Road, okay, and now we get on our car and we drive through somebody else's formerly rural area to get to our home, okay? So the idea that something is maybe adds to our ride 5 minutes is not necessarily against a regional plan. Would you agree with that?
Would I agree that driving through neighborhoods...
No, would you agree that a slight increase in your drive time does not necessarily break our regional plan?
I don't think it's spoken to.
Slight? Okay, now, and I'll just give you an example. Today I went to Dirty Mills, okay? I started Stern School, and I went past to Washington Street. Okay, you're familiar with the area, right? I probably passed about maybe 4 million square feet under the roof at that point. It took me a total of 6 minutes at 4 o'clock in the afternoon to get through all the series of lights. Okay, so again, there's a slight increase in travel time. Does that break, in your opinion, professional opinion, does that break our regional plan? Because the reason I'm asking is this: you're a planner, he's a planner. I'm sure you two have worked together in the past, correct? On different things.
We have worked with the company.
Okay. Is there any reason for you to believe that the professional staff of the county is not up to the task of overseeing this to the point where this will be a complete disaster, which nobody wants for the residents in the area?
I'm not suggesting that the county is not capable of doing adequate supervision. What I'm indicating is that you have a plan, you are being asked to modify the zoning on the basis of ignoring the plan. You have not been asked to consider what are the regional impacts of this that would suggest that it is consistent with our plan. It is inconsistent with your plan.
The plan...
The staff has indicated it's inconsistent with your for a plan.
Well, look, the zoning changes all the time. Would you agree with that?
Yes.
So zoning requests come in all the time.
Uncommonly in a way that is contradictory to the plan.
Planning, well, by your own plans, you had residential, you had commercial anyway.
There was a mixed use.
Okay, so in other words, this is open to debate.
Well,
it's not like, it's not mathematics where there's 1 + 1 is always going to equal 2.
No, you are absolutely correct. This is a judgment of whether or not it makes sense.
Okay, all right. Then that's kind of, the point I'm trying to get at is, as a regional planning commission, I'd say number one, is the you'll agree with this certainly, is the impact so inconsistent with what's going to happen and what's in the best interest of the county? Or do we look down Route 12 and we say, okay, we're going down the road someday in the future, what we're likely to see, what's consistent with what's going on around it? Because something like I've heard a lot during the discussion, I realize I'm editorializing a lot as much as I'm asking the question, but I appreciate your expertise. Would you agree that something like we've heard, well, we don't want Woodfield, we don't want Schaumburg, we don't want Gurney, whatever it is. Would you agree that one development does not a Schaumburg make? It is a mindset, it is a commercial mindset of the city fathers or city pairs, I guess I should say at this point, to have that happen. So we could say, all right, this property here, we've got 2.5 miles or so with Coles, I think is kind of as I look at it on my car. One 800 square foot under roof development does not a Schaumburg make, so that it would be inconsistent with anything. In other words, if everybody else has no development, then you've got one place that's 2.5 miles from Coles.
On its face, your staff has indicated that this is a development of regional impact.
Okay.
This is a development of regional impact. Any jurisdiction would look at this as having impact that is larger than a 5-mile area. The 800,000 square feet, if that were to come to fruition, is a regional shopping center.
Okay.
That's not an isolated spot on the map. That is a development that will affect the county. It will affect the county's balance. It may not generate anywhere near the amount of commercial sales taxes that have a regional impact from a revenue standpoint, but from an impact on land uses in the area, it's regional.
So, in your opinion, how about 25 acres?
25 acres is what we would consider a community level size center.
So if the proposal had been 25 acres, we wouldn't have been here 5 times in the last 2 months?
I think that you would have been still recognizing the fact that the 2 municipalities, under the encouragement and guidance of the county, went to the extent of working out what made sense from a land use standpoint and including it in their comprehensive plans, and you included it in your framework. And you would still be here discussing the fact that you're ignoring those.
That's right.
Yeah. And it's supposed to go to, is a 20-year plan. So does that mean for the next 20 years that nothing's can change?
No, it doesn't mean that.
Okay, so plans are made to be changed, can we say?
No.
Okay, well, I guess that's where we disagree, and I guess at that point, I have no further question.
We agree to disagree.
Thanks, Mr. Chairman. I just have a few follow-up questions.
You promised?
Promise. This I'm directing to any of the village attorneys or our county. Is there a precedent anywhere for the success for approving a pattern book as a preliminary plan, as sufficient for a preliminary plan? So whoever, Mr. Braithwaite, you're taking the first shot.
And you have my blessing to answer the question.
I certainly know of no precedent for property being rezoned solely on a pattern. Now, I realize in saying that the county staff will tell you that there's going to be protections to come in the next few years, and they have 5 whole years to apply for that protection. But that really touches on a very salient feature and a point in this matter. What happens at the end of the 5 years, having been zoned commercial? Mr. Dimucci comes in very good faith and says, I tried. I can't find a commercial development.
Mr. Braithwaite, I am going to ask you about that extension process, but and I want to hear your response. But my question right now is a very focused one, which is whether or not anyone knows of any precedent for approving in a matter like this, the zoning change like this, preliminary plan for it, based solely on a pattern.
I know of none. That is not to say that I don't know of every case in the United States. But certainly, if it were something that were done commonly or even done at all, I think I would be likely to have heard of it.
And Mr. Shapiro, can you answer that, please?
Earlier in your comments, Commissioner, you indicated that there was no evaluation with regards to traffic, utilities, et cetera, because in your thought, in your opinion, this application was lacking in not necessarily details, but necessary information.
Yes.
To look at it and to evaluate it. To answer your question, with specific regard about the word precedent, I'm very concerned that if this application were to be approved as is, this body would be setting the groundwork for a future precedent to approve of plans when there is an inadequacy, to approve of applications when there is an inadequacy of plans for which it cannot be done.
So and then your answer to my question then is, you do not know of any precedent, any time that a pattern book in our county or elsewhere in the state or anywhere has been used as solely as the site plan, meaning our details, for this kind of a request.
I'm not aware.
And county?
I would disagree. The concept of a pattern book has been used more than once within the boundaries of Lake County.
I understand that, but my question is very honed, and that is, it's the sole basis here. The sole form of the details here is just in that pattern.
I would respectfully indicate that the details embedded in the pattern book are not the only details in the application.
Well, all through all of this, we've said that it's in the pattern. Everything refers to the pattern. In our county, let's start there, have we ever had an approval for a request such as this based solely on a pattern, like you're doing here?
The pattern book accompanies a concept plan. That combination of proposals.
You don't have a concept plan.
There you go. We have a concept plan in staff's opinion, and that combination of proposals has been proposed in the Cornerstone development, for example, Pacific area, the Cornerstone development in Grace Lake area, the 94-173 corridor plan for that intersection. The pattern book concept has been used in conjunction with a concept plan in both cases.
I understand that, but here's the dilemma. Before our county, and I certainly will look into those others that you're suggesting, but I've looked through, and I don't know of anyone, anywhere, where we've done this process this way. Because as you said, the ZBA is not going to have the final plan either. They're going to be approving the preliminary plan. Now they can ask different questions in different areas and get maybe some restrictions put in, but they're still approving the preliminary plan, right?
The RPC does have a role in reviewing the preliminary development.
No,
That's correct.
The ZBA, I said.
The ZBA does as well.
Okay.
That's right.
So that when the final plan is in place, so when there are all the specifics that normally are present at this stage, or at least some of them are, that will only go before PP&C, is that right?
The final development plan approval stage involves the committee's review and decision
So
to
that's
make sure
it.
that all the conditions are addressed at that stage.
So do you know, there's, I mean, just without, I want to be direct here and not play any games. I don't want it to be conceptually based on a pattern book. This is based on a pattern book, except for that very pretty little drawing. Now, has there ever been a precedent that you know of for this kind of request being successfully approved?
Again, I refer to the previous examples, but it is an innovative request. The use of a pattern book. I apologize.
Yes or no?
As I said before, there are these examples already in place, but it is admittedly a novel, innovative sort of proposal.
So the answer is no.
Mr. Braithwaite, I would like to follow up with you on explaining to us your answer to the question regarding the extension past the 5-year period.
What was the question?
If they are not successful in procuring a developer within the 5-year period, you wanted to iterate about what would be the process then, and that I'd like to give you that opportunity.
My professional opinion, which is based on, first, my years of practice, based upon the case law, and I suggest based on common sense, is that at some point, presumably 5 years from now, if the developer has not found the use for this property for which he is seeking zoning, even if by that point there is a special use in place, if he then comes back to you or your successors, the zoning board, county board, and said, look, I tried, and in good faith tried, but the mark is just not there, and it's not going to be there in the immediate future. Therefore, I now want to up-zone. I want to make it a better zoning. If you turn that down, I suggest to you that the courts have indicated they would overrule you and grant him relief. What I'm speaking of is upzoning in terms of office building, no sales tax, upzoning in terms of, you and I may not look upon this as upzoning, but in the normal ladder of zoning categories, it would be upzoning. Upzoning for multiple family, whether rental or condo, and all the burdens that would put on the communities. And on paper, that looks better than an 800,000 square foot shopping center. And that, ladies and gentlemen, is an underlying concern that has been with us from day one here.
Would you repeat that again, please? Would you say that again? Can you repeat your last paragraph there? What your underlying concern was? I kind of heard the way it was kind of going. Would you say that again, please?
I'm sorry?
Your last paragraph of your answer.
Regarding the request and the upzoning and how the
You say one of your underlying concerns, the last 3 sentences that you said, if you can regain your thought on that one. Remember?
I still don't understand your question.
He didn't hear the last portion of your response.
Very last portion. Thank you.
I'm not understanding you, you're not understanding me.
You almost like I was a lawyer for a second.
I can assure you that I could make myself understood without the microphone. What I was commenting on is upon a failure to find a developer, the the petitioner could come in and seek what we call upzoning, a better classification of zoning. And one of the many possibilities would be, of course, one possibility would be single-family homes. I don't suggest that he's going to do that if he's already had commercial label applied to the property. So the other categories would be an office building or a series of office buildings, or multiple family, whether it's condominiums or rental.
Thank you, Mr. Bradley. My next follow-up question is, Mr. Shapiro, you said that you wanted to respond to some of the utilities issues, specifically sewer, I believe.
Last August, there was a court proceeding where utility issues for this parcel came up. And I'm shuffling papers here because I'm looking at the transcript of the court ruling. And I want to just address that portion, that small portion of the court ruling that dealt with sewer to this piece. I think it's important for you to know. Take me about 15 seconds to read it. This was before Judge Hoffman last August. Hoffman Woods was consenting to construction of the sewer line up Route 12, but was not consenting to service being extended to an individual parcel within their jurisdiction without further consent. Now, what I'm about to read will give context to what I just read. The evidence that the hearing makes clear is no actual service line has been extended to the Taubman Dimucci property, which is currently vacant. This reading is also consistent with both the 2009 sewer agreement and a letter from Village President of Lake Zurich Grant. Under both of these documents, it is recognized that before a sewer line is extended onto the actual Taubman Dimucci parcel, Hawthorne Woods must give its consent. This also makes sense because Hawthorne Woods would have to give up its right to the 750 PE reserve capacity for that property, which it has and will continue to have. So, with regard to the sewer, thank you for allowing me to address that. As a judicial finding by Judge Hoffman, August 5, 2001.
Thank you very much. And is Janet still here from ACOG? My final thing is regarding Mr. Ivan's opinions about the aquifers in our area and the availability of water without impacting neighbor wells. Does BACOG have something to say about the aquifer issue?
Yes, we've been doing groundwater study at BACOG for about 11 years. We work with a consulting hydrogeologist. We have members on our committee from the Illinois State Water Survey and the Illinois State Geological Survey. So this is not a purely grassroots effort. We've developed a three-dimensional model and mapping of the shallow aquifer system. And about 95% or more of the wells in our area are in the shallow aquifer system. I'd like to correct some of the information that he stated. Shallow aquifer system is a system. It's one system and it's one water source. There are not separate areas that are separate sources, so that if you draw water from one pocket of water, your neighbor's well is in a different pocket, they're not connected. They are connected. It's one system. This is water that is in glacial materials from the glaciers that were here 10,000 years ago. There are cracks and fissures. There are that transmit water. There are pockets of sand and gravel. There is fractured bedrock down on top of the bedrock, which is the very deep. It's the bottom of the shallow aquifer system, but they're all connected. The water flows horizontally, it flows up and down, it flows generally from east to west. So we know all this from the mapping that we've done. But the point is, it's all connected. You can't draw water from a well at one site and think that it's not going to affect the wells in the surrounding areas. There are pockets of water where one well may be located that are separated by aquitars. He used that term, and that is a term. But that your well and my well are in different sources of water. It's all the same thing. So what happens in one area with the well, with the groundwater, affects another area that's nearby. Now, he also said that he would be required to do studies, and he would not be allowed by putting a well in to dry up somebody else's well. That is not true. In the state of Illinois, we're governed by the law of reasonable use. It's not a particularly good law. What it says is you can put in a well wherever you want. You can draw as much water out pretty much as you can get. And if your well dries up your neighbor's wells, that's their problem. It's not your problem. So if a well goes in at this location,
I think you did answer Rainey's question. She's adding testimony right now.
Let her finish. Let them do it.
I think she's responding to Mr. Ivey, who I thought was just giving his opinion, and Baycott has used experts, and I think this is very informative.
Let her finish.
Okay. Thank you very much. What was there specific question?
I'd like to be able to finish her thoughts there. Frankly, what they're saying here is that they're going to not impact neighborhood wells should they have to use wells here, and that's just patently untrue.
We'll have discussion between us to be able to discuss this. Yeah.
Thank you.
You have all the information. Just let her finish.
I think we have had an adequate amount of information on that subject.
Know your vote. Put the Dimucci's people out there. Let them. We know your vote. Yeah. Good job, Chairman.
Okay. Craig, do you have anything?
Don't want to hear the truth. Trust.
Larry, or is he?
No, nice.
Oh. Does anyone else have any follow-up?
I would love to ask if the COO from Hawthorne Woods and the representative from Baycott could come back up. I'd like to ask both of you to respond to a couple questions, please. I would really love it, I know this is a theoretical, I would really love it if everybody else in this room wasn't here right now, because I would really love to escape from all the legalese that we've heard from all sides tonight and talk homeowner to homeowner. Like the next part of what I'm going to say. My background is as a horticulturalist, a landscape architect, and an ecologist. At first glance, when I look at this plan, I'm thinking they're way under what they could develop in terms of square footage for the space. They're way under in terms of what they could develop for impervious surface. There are assurances for how it's going to look, which we may not all agree with, but at least they're there. And there are rules in place through SMC for impacts to our water storage, detention, and quality. So I gotta say, 51% preserved as open space, at first run through this without impact to schools from residential, doesn't look that bad. So my specific questions to you as homeowners, as people who live here, is it the impacts that you object to? Is it this change to going all general commercial that you object to? Is it the proportion of open space? Or ultimately, is it the process?
Well, I could talk about all of those items, but let me try to summarize the Village of Hawthorne Woods' opinion on that question. Or are you asking just me personally?
I'm asking you personally as a Hawthorne Woods resident. Just talk to me.
I need to clarify for the record, I'm not a Hawthorne Woods resident. I'm an employee of the Village of Hawthorne Woods. I'm the Chief Operating Officer, Village Administrator. I could answer your question based on that profession that I am retained within the municipality.
As a representative of those residents.
I can, and I represent these residents every day. The reason that we object to this particular proposal are actually many. But in regard to your first question regarding the open space, in the application itself, you'll see, and I believe it's chapter 15, which is the utility analysis, this proposal cannot be developed on more than 44 acres according to the own engineer's testimony for this type of development because of the hybrid soils and other condition restrictions on this site. So while you might see a very generous 51% or so gift of open space, it's because they can't develop on those 51 acres according to the study that I read in the application that you all have at your desk. Please read it. It's on page 4 of chapter 15 in your engineer's summary. In relation to the other question, just speaking person to person, we have always been concerned about the size and scope of this particular submission. And the reason we're concerned about that is because there is an allowance. In the submission page that you showed, Commissioner Ray, you held up what has been referred to as the cartoon diagram, that is the concept plan. Right there on that very page, it says up to 800,000 square feet. Those of us who deal with land use and development in municipalities every day know how big that is. Some of you sitting here may not know how big that is, but it is comparable to the Hawthorne Center, less the Sears store. So it's the size and scope of the application itself that would be our secondary concern. To answer your third question, I'm trying to remember them in order of what you gave. Of course there are environmental impacts, but it's also the application itself. The RPC is charged with rendering an opinion on a planned unit development where there isn't a plan for the community to review and feel these assurances. There aren't a number of units that are restricted, and there's not a development for us to comment or review. So we find the process flawed in and of itself, that the application is not complete for you to move even to the very next step. And then finally, I think your question, generally overall, I'm sorry, what was your next question?
The final question was about the process.
Well, of course, the process itself, I will stand here and admit to you, 10 years ago I was not involved with the village when this first came forward, and I admit that process was flawed for not including the owners of the property. But I think, as Attorney Braithwaite said, the people that were dealing with the development at that time were the developers. There was a set development plan. There was a set company that was looking to purchase the property at that time. They were known as the Taubman Group. Thank you. And so the communications were primarily with that group. The reason the process is so flawed, that I hear from the residents, and trust me, if you think you heard from the residents, I heard from the residents as well. And I think I can express their voice in brief. They're concerned because there is no developer for them to talk to. There is no plan for them to review. The cartoon that you have before you does not even show a connection to Old McHenry Road, shining those headlights in their homes. It's because there isn't a process as usual that the county has ever gone through before. This is, I think I heard the word innovative or unique. This is unprecedented. And so the people gather night after night to speak to you because of the process, because of the size and scope, because it doesn't follow a typical procedure for rezoning, for conditional use permit, or for a 5-year extension that has ever come before you. And because it's 110 acres, it brings people out like I've never seen before. And I hope those opinions that I just expressed reflect the concerns I've heard.
Thank you very much, those of you. I'm sorry for you to do the same thing, but again, if you could just comment briefly on your behalf as a local resident, is it a concern about the impacts? Is it an objection to the general commercial rezoning and removal of residential? Is it the proportion of open space, or is it the process?
First of all, I'll tell you that on a personal level, my degree, my master's degree in planning is in city and regional planning. So I'm not a site plan evaluator, I'm a regional scope perspective kind of person that goes way back. So when I look at this proposal, your planned unit development request, I don't see any plan. I don't see how, I don't know how you can evaluate how it fits into anything. The framework plan, the surrounding neighborhoods, the county, our communities, any of them. And our communities are your communities. I'm not talking us or you, it's all of us. So, you know, that's how I'm looking at it, person to person, resident to resident. I moved out to this area for the character of the area. I moved from Chicago, but before that I moved from central Illinois, where it's open space and farm fields and so on. This area, this whole area, has character and sense of place. This community does. I don't see how an 800,000 square foot retail development fits quite in this area. So I'm going to move into, impact. How do you evaluate the impact? I don't know. But 800,000 square feet of anything that's retail is going to impact the area in a significant way.
I just want to clarify, even though that's significantly under what is technically permitted in the zoning.
Only residential.
True, right, I see. I'm saying based on comparison to general commercial zoning or the PUD. So those comparisons were given to us. And that I'm just asking for clarification.
And it's not about commercial. It's not about commercial because our position is, there's commercial on Route 12 and it's a major arterial. But it's about scale, scope, size, all of that.
And lack of specificity.
Yes, but we don't know what that is. It's 800,000 square feet of something, which is really big on a really big site. But I think the main thing that we have focused on in our comments from BACOG, and that's not just me, that is you have had, I think at least five of our members from the Barrington area come and speak to you in the previous two hearings. And they have spoken about the relationship between the county and our local governments, our municipalities and our townships. And it's about trust. There is the existing intergovernmental agreement that was developed with the knowledge and support and nurturing of the county. The county at this point is saying, hey, it doesn't matter to us. We're not a party to it. We're going to ignore it. And
You've answered Rory's questions. Thank you.
But thank you for the final part about the process. I do feel that the
Trust, and the trust. Don't forget the trust.
Is there anyone else on the commission? It is now 4:09, and I had hoped that we would get to a point where we could have had a motion before, that we could start that element. So, I think it's totally unrealistic to even consider. Is it 9:30?
Yes.
Well, I thought it was 9:30. I apologize.
I've been asked to put this motion on the floor just for the purpose of discussion, not necessarily so that these commissioners can discuss it. So I'll put it as such. In the case of the Dimucci family application, I will make a motion to recommend the approval of the requested rezoning for estate to general commercial, approval of the conditional use permit, and approval of the planned unit development, PUD, preliminary development plan. This motion is subject to a further request that the ZBA, PB&Z Committee, and the County Board condition their approval on the following considerations. Number one, that sewer be available at the time of the final development plan approval. Number two, that traffic improvements will be made in accordance with the county's access control ordinance and the IDOT access policies. That full compliance with the applicant pattern book be made a condition of the approval of the final development plan. Number four, that the proposed open space on the site, approximately 50% of the site, be permanently preserved through a legally binding encumbrance. And number five, that issues of scale, height, bulk, setback, buffering, and screening, lighting, use restrictions, and stormwater management be reviewed in more depth by the ZBA so that appropriate conditions will be imposed upon any development occurring on the property. Motion.
Is there a second?
I'll second it.
Motion made and seconded by Craig. Now we go into any discussion as far as the resolution or the motion is concerned right now.
Because
Proposed open space on the side be permanently preserved through a legally binding encumbrance. I would like to see that expanded somewhat so that the final restrictions go with the property regardless of ownership.
can I amend my application to
As
include that as well?
a conditional use permit, that is binding on the land.
Yeah, I think it's up here. I accept it for the
So this is,
and
Dimucci can sell the property to X, Y, and Z, and these conditions are still.
is it possible to also amend this? I think that the attorney does have a good point in that, and it is a concern that 5 years down the road, if good faith effort, is it possible to expand that to be like 7 years or 8 years before that provision would set in there to give municipalities the assurance?
What's your point you're trying to make?
The attorney for North Barrington had mentioned that after 5 years, you can ask for an upuse of it to be extended. What if we extended that beyond the 5 years to further bind that property to this alien here?
This resolution binds it.
No. But as the attorney pointed out, which I think is a good point, as he said, that, and as a natural consideration, hey, after 5 years, if the Dimuccis have done everything they can to market the property, they can't do so. They can go back with some relief from the court by precedent and basically turn it to something else, multifamily or apartment buildings or something that they wouldn't want. Is it possible to extend the terms of that so that that would give them a further assurance? If that seemed to be a pretty sincere concern, a legitimate concern.
Eric, to answer your question, the mechanism for the extension is a request to extend the length of time before which the final development plan stage would occur. And so, as it relates to a situation in which the property owner would come back and say, I can't live with this plan anymore, they would have to go back through the process from the very beginning, all through the regional planning commission stage, the zoning board of appeals, the planning building committee, and the county board. They would have to start over. That's the mechanism. There's no more assurance possible beyond having to start at zero.
So whatever the current state of affairs as exists at that point, does that continue beyond that time?
If the committee ultimately decides to grant an additional extension to give them more time to the package and development proposal for that site, if they choose to extend that process, that gives them more time to try to make it work. If they don't extend it, then that's where the development proposal stops.
Mr. Chairman, I hate playing lawyer to these things, but I will anyway. I think there's a little bit of confusion, I think. We're talking about two different things. Any restrictions that go on the property as a result of the application, if the application dies in 5 years for lack of action, all those things go out the window. It becomes a farm field again, and they have to reapply. I think, Jordan, what you were getting at was a mechanism where the petitioner would agree to open space restrictions regardless of what happens with the application.
No. What I was saying about the attorney raised the concern, if I understood correctly, he was basically saying, and you give me a nod or no, would be that through court precedent in previous instances like this, after that period of time, they can then go for basically a more intensive or different use that would be much less in keeping with what we are.
Right, now, if they're going to argue for that, then the judge gets to write whatever he wants in that sense.
Right, right. So my thought was, what if we said, all right, let's extend the terms of everything so that that day would be further in the future. So that would give it implication.
As for 5 years, you're saying.
Right, right. Given the state of the economy, I mean, I've heard predictions that it's going to take 10 years or 20 years to do that. That's why I'm asking.
Well, I'm not in the environment, I've learned that one.
The application lists for 5, and then we can't change that.
I frankly, Jordan, I don't share the concern. I think to Mr. Braithwaite's degree about the likelihood of upzoning after 5 years. I think it's better to address the proposal before the board for the 5 years and just deal with that, because then we get into reworking the petitioner's proposal.
Also, to address your concerns, there is no plan here.
I understand.
So what the ZBA would be putting restrictions on, and in your last sentence of your motion, you mentioned things like screening, setback, whatever, is irrelevant if they don't know what's going to be developed.
But based on the conditional use permit, it would have to be this, or it wouldn't be following the permit.
But let's play out that scenario just for a moment here. Okay, just like we can't decide what the impact on the community surrounding this, nor our framework plan will be, unless we know what is going to be developed there. Because there are significant differences in the impact depending upon what's going to go in, let alone the size and scope. So if the ZBA is going to talk about details, first of all, we already know they're not going to know about traffic. How can they buffer the surrounding area from traffic if they don't know enough to have a traffic study? We've already heard that. How do they know what type of screening is appropriate? There may not be any screening really needed if it was some, small scale development right along 12. So, I mean, I think what you're saying just doesn't make any sense.
No, but I guess I'm going back to what you said, which was assume the worst.
Well,
assume the most intensive use. That's kind of, I'm assuming that every bit of 800 square feet gets developed.
Well, actually,
okay, that's what I'm going back to. In my thinking, I am not assuming, well, let's downsize it. Let's do everything to the max, and let's operate under that. And then say, as a regional perspective, okay, and let's kind of put in a Walmart just for, it's probably about more than 100 to, I think the huge one in Virginia is like 200,000 square feet, okay? Most big box stores now are, and you can correct me if I've done a little bit of research on this, are north of 100,000, okay? So we are theoretically talking about, just make this really simple, 6 to 8 big box stores.
Yes.
Okay, does that make sense with everybody? No?
No.
Is that regional impact, what is that going to do? Is that in keeping with what could happen on Route 12, number one? Number two, how is that going to affect the surrounding community?
And I guess my point is, until we know what's going to happen, see, the entire, you talk about Route 12 like it's one entity. And I know we have the Route 12 corridor, but the Route 12 corridor people, if they were here, would say that it has to be solid, intense development.
And probably shouldn't, which is why it's better the way it is, because essentially what you have, it doesn't just say that the Dimuccis did find somebody to buy the property and they did develop it. Well, essentially what you do have a 2.5, 3 mile span where traffic, in the absence of a traffic study, which I agree I'm not happy about, but in that 2.5 mile span, that really gives the traffic time and space. Right? So then, I'll think of 30 those things. Okay.
Let me address one thing.
Well, let me finish it, okay? So then you're looking at it and you're saying, okay, from the time, I'm going to use the Coles on the west side there of Route 12. As you're going towards the current, the subject property, there is that opportunity to give some space to the traffic, which means theoretically, from a traffic perspective, you're going to, now, it's going to obviously be different at 1 o'clock in the afternoon as opposed to December 24th at 11 in the afternoon. But it gives it some time to space itself out so that the traffic impact is actually really significantly reduced because there's not a lot else there.
Gurney Mills has a 6-lane expressway.
Please.
I'm talking, well, I'm interested in
That's why the traffic isn't short.
I'm talking about Hunt Club Road.
Jordan, don't respond
Hunt Club
to
Road,
your
okay? I'm not talking about the expressway. I'm talking about Hunt Club Road in my experience this afternoon, okay? So I then, as I'm thinking about what this is, I then look at it and say, okay, there is this time where traffic could potentially stop for a few minutes, depending on the time. Is that inconsistent with the regional plan, number one? Number two, is that a hardship for the community? So I actually look at it, which got back to the point that I was making with the planner earlier, was that something like Schaumburg, that's a mindset. The development of Gurnee, that's a mindset. That's an agreement by the municipalities that we're going to go commercial. If all 800,000 square feet goes under roof and nothing else happens right there because the municipalities put the brakes on it and say this is all the development we're going to have, because we don't want anything else, what then is the impact of the community, and is that in keeping with the regional plan?
Just a yes.
The question has been called. Meg, please call the roll. Okay, let me, before we take them, I want you to understand what's happening right now. We are sending to the Zoning Board of Appeals this application with the recommendation or lack of recommendation from the RPC. This is going to the ZBA with a positive or a negative. So that if this thing is voted down, that does not mean that this thing has been stopped. The process is going all the way to the county board. So make sure that you understand that. May I call the roll, please?
My recommendation is no.
My recommendation is yes.
Ellison?
No.
Bobby?
Abstain.
Lynn?
No.
Jaworski?
Yes.
Holmes?
No.
Red?
No.
Bannon?
Yes.
Of course. Of course. Of course.
5-3 is the vote. 5 no, 3 yes. This way
Doesn't mean anything. Doesn't mean anything.
Thank you.
Doesn't mean anything.
Motion made, second. All those in favor say aye. All those opposed say no. Motion carried.
Okay. I like pizza.